Good afternoon, everyone. Hope everyone is doing well.
Yes, Your Honor. Good afternoon.
Give the court a moment. I'm still waiting to get the calendars, and we will get started as soon as the jail is ready.
Yes, Your Honor.
Hi, how you guys doing?
Judge, as the court is getting ready, I just want the court to know that I'm the attorney Terrence Bradley here for Miles Carr. Just to, when that position comes up.
Good afternoon, Mr. Bradley. Thank you. Glad to have you.
Thank you, Judge.
And let's see, the state all-purpose calendar reset date is going to be February 2nd. Let's see, are we ready in courtroom 3?
How you doing, Judge?
Afternoon.
All right. I'm the brother of Clarence Hale. Visiting.
Okay, Mr. Hale, we will be with you as soon as when Mr. Hale comes up. If you'll just let me know that you're here, I'm happy to hear from you at that time, okay?
All right, thank you, sir.
You're welcome.
For me, y'all, please. I only have her position on here.
Well, what's
Yes.
her name?
Good afternoon, Your Honor.
Good afternoon.
Pronounce your last name for me.
It's Reese. I'm attorney Laura Reese, R-E-I-S. I'm an officer of the court as well.
Number 24.
Thank you. Good afternoon, Ms. Reese. I'm Judge Eric Mario. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Thank you. You have been charged in case 23 CR 0000417J with battery family violence. Is there a history? Mr. Howard?
Third arrest. Last arrest was in November. Done with it. Theft of services, obstruction, felony, disorderly conduct. That's opening the cab. And 2018 hit and run, dismissed.
Okay, and who's representing Ms. Reese this afternoon?
Your Honor, in Dunwoody, that was a misunderstanding.
Hold
at
on,
Caesar's-
Ms. Reese, for me, okay?
Yes, Your Honor.
Thank you. Good afternoon, Ms. McLeod. Is Ms. Reese your client?
Yes, Your Honor, but I haven't had the opportunity to speak with her yet.
Okay, so we're going to need to allow Ms. Reese and Ms. McLeod to speak. I don't know if there's a phone in courtroom 2 or not.
I think
There it is, Your Honor.
this is Your Honor, so they hadn't gotten around to calling me yet.
Okay, so Ms. Reese, we will be back with you as soon as we give Ms. McLeod the opportunity to discuss your matter, okay?
Thank you, Your Honor. Position number 6, Ms. Bush.
Good afternoon, Ms. Bush. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 23 CR 0000429F with simple battery family violence. Is there a history, Mr. Howard?
Yes. I see 2015 out of Florida, petty theft. Before that was 2009 probation. 2009 stalking conviction out of Florida. Last arrest in Georgia. 2014 possession of a Schedule 4 controlled substance. That was dismissed.
For you.
Okay. Good afternoon, Mr. Rogers.
Good afternoon, how are you doing? My dad is ready to post bond.
Okay, you can proceed.
I just have to
On
get.
November the 4th of 2022,
I'm sorry, I'm sorry. Okay, go ahead, Mr. Rogers. Stay muted. Go ahead.
okay. On November the 4th of 2022, officers arrived at 250 Ridley Valley Road in reference to a domestic dispute. The victim, who is Rosalind Bush, reported to officers that her daughter, Courtney Bush, appeared at her house at a residence requesting money for rent. The victim stated that she knows her daughter to use drugs and to get money in order to satisfy her habit. She refused to provide her daughter any money, and her daughter, Miss Courtney Bush, did in fact punch the victim in the face multiple times with a closed fist. Her mother is 78 years old, Your Honor, and those are the facts. With the state is requesting a $5,000 surety bond due to the victim's age and injuries sustained, stay away order from the victim, Rosalind Bush, and a stay away order from the address of 250 River Valley Road. And that's all, Your Honor.
Have you and your office spoken with the alleged victim?
I think our office did reach out to the victim. We were not able to speak with the victim, I don't believe. One second. Yeah, we left a voicemail, but we were not able to contact the victim.
Okay, thank you, Mr. Rogers. Good afternoon, Ms. Gant.
Good afternoon, Your Honor. Ms. Courtney Bush is 36 years old. She has been in the Atlanta, Georgia area for 20 years. She informs me that she is the primary caretaker of 3 minor children, ages 18, 10, and 2. She is not receiving any child support, and she actually lives with her mother at the incident location, 250 River Valley Road. Ms. Bush has some college. She studied business, and Your Honor, at this time, she's disabled and has been so for about 5 years. I did reach out to Ms. Bush. She informed me that she would be attending the hearing to address the court. She states that she wants to have contact. My client strongly denies the allegations, Your Honor, regarding my client's history. I did not hear about any convictions of violence. My client was unaware of the warrant. She learned of it when she actually went to make a complaint against her, I guess, boyfriend or fiance for abusing her. We are requesting a signature bond on Ms. Bush's behalf. We are opposed to the stay away and the no contact orders, as again, I did speak to Ms. Bush, and I think that she stated that she would be in the courtroom today, as opposed to appearing by Zoom. I do not see her on Zoom.
Okay, I don't have anyone in the courtroom with me other than personnel. So, given that you've spoken with her, Ms. Gant, it's going to be a $5,000 signature bond through pre-trial per the judge. 1-day anger awareness, no further violent contact with Rosalind Bush, no drugs, alcohol, weapons while out on bond. All right, good luck to you, Ms. Bush.
Thank you, Your Honor.
Did you say anger awareness?
Yes.
You did, okay.
What was the bond amount? I'm sorry, Judge.
$5,000 signature bond through pre-trial per the judge.
I thought he was not there. I thought
Condition number 9 is next.
So when I got there, I thought he was not there, but then he appeared. Show the correct account. We're pending.
Good afternoon, Ms. Doubleday. My name is Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Your Honor, I hate to interrupt, but Attorney Ray Giudice represents her, and I think he's at the jail. I know he texted me. He's at the jail parking now, so.
Okay,
Maybe
thank
move
you,
on.
Thank you, Ms. Melnick. Can we come
Sorry.
back to Ms. Doubleday?
And
Should be outside
in
the
the
lobby.
future, what I'll do is
Position number 12, Judge.
and I'll make sure that it's okay that. And so that's how I'll remediate that.
Never mind.
Position number 13, come on, Dakota.
And so I would ask that,
Welcome back.
thank you. I would very much
I'm
like that. Thank you.
sorry. Two thumbs up.
Good afternoon, Ms. Hilliard. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Yes, okay, she's giving me a thumbs up. Ms. Hilliard, you've been charged in case 23 CR 000410J with battery. Is there a history, Mr. Howard?
No.
First arrest, okay. Good afternoon, Mr. Abdullah.
Good afternoon, Your Honor. The facts show that on January 21st, 2023, officers responded to a physical dispute call at 240 Amal Drive. Upon arrival, they met with the victim, Imani Weems. Ms. Weems told officers that she was at work when the defendant approached her and assaulted her. Ms. Weems was pushed by the defendant and a scuffle ensued. As a result, Ms. Weems suffered from scratches on her face and hands. At this time, the state is recommending a $3,500 surety bond. As to the battery count, no further contact with Imani Weems, a stay away from 240 Amal Drive, no weapons, drugs, or alcohol, and a one-day anger awareness course.
Okay, Ms. Melnick?
Yes, Your Honor. As it was indicated, the defendant, Ms. Hilliard, has absolutely no, has absolutely no criminal history. She lives with her mother. She has a very steady residence. She is a full-time resident in Georgia. We're asking, given her history, and this was a security guard in an apartment complex, we're asking for a signature bond with a stay away. And we're asking for a signature bond in the amount of $3,000.
Okay, a $3,000 signature bond through the jail. No further contact with Ms. Wing. Stay away from the Amal Drive address. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Hilliard.
Judge, if we can go to Alpharetta Jail next, please. Thank you.
Okay.
Thank you, Mr. Hale.
Where's the Alpharetta? Is the Alpharetta jail on?
Yes, they're logged on.
Oh, there we go. Who do we have? We're ready for you, Alpharetta jail.
I'm ready to go, man. I'm ready to go back to work and get rid of my.
Hale, Clarence Hale.
Number 11,
What's your last name again?
Hale, Hale.
Hale?
Yes, number 11.
Thank you. Good afternoon, Mr. Hale. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, that's fine.
Thank you. Mr. Hale, you've been charged in case 23 CR 000437H with driving under the influence of alcohol, thus safe, willful obstruction of law enforcement officers, expired or no license plate or decal, and improper or erratic lane change. Is there a history, Mr. Howard?
The second arrest, last arrest was back in June for DUI out of Sandy Springs.
Okay. Mr. Abdullah?
I'm sorry, Your Honor, this isn't my,
Okay, who's presenting for the state?
Your Honor, I'm so sorry. I just got let into the Zoom a minute or two ago. Can you let me know which case you're referring to?
Yes, good afternoon, Ms. Falk. We're on position number 11, Mr. Hale.
Clarence Hale, that is mine, Your Honor. Just let me have a moment. My computer entirely shut down and I had to restart all of my functions.
Okay, you're fine.
Good afternoon, Judge. While you're waiting, I didn't mean to interrupt. It's Mr. Edie. Just for the sake of time, I wanted to let you know that I represent Kanisha Jenkins and I would like to speak to her first. I was just reached out about an hour ago.
All right, good afternoon, Mr. Edie. I'm not sure where your client is, but as soon as we locate your client, I'll see that if we can put you, if you can call to speak with.
Okay, thank you.
You're welcome.
Okay, Your Honor, I am prepared to go forward now. Just needed to get back into my Odyssey. All right, Your Honor, in this case, the defendant I'm seeing is charged with DUI less safe. In that incident on January 21st of 2023, the defendant was driving at 2:29 a.m. on Mansell Road, North Point Highway. That's in Alpharetta. The defendant in this case was driving less safe. An odor of alcoholic beverage was emitting from his person when the officer pulled him over. The defendant admitted to drinking alcohol prior to driving and apparently did fail the field sobriety evaluation. In addition, the defendant physically resisted the officer, Officer Noble, by pulling away and keeping his hands under his chest on the ground, despite Officer Noble's commands to move his hand so he could place him under arrest. The defendant also had a expired registration, which expired on December 4th, 2022, and had not been reinstated by the state. And this defendant was also, what predicated the stop was that the defendant was failing to operate the vehicle within the single lane of Mansell Road. He had crossed over the lane lines, which was observed by the officer, which was the reason for the stop. Looking at this defendant's history, as you can see, he does have one prior arrest from June of 2022 for the same charge of driving under the influence. That's a concern for the state because within 7 months, the defendant has now had 2 arrests for DUI less safe. That is his entire history at this point. The state is asking for based on this, we're asking for a $5,000 surety bond on the DUI less safe and $500 surety on the willful obstruction, driving on expired tag, and improper lane change for a total of $7,500. Excuse me, $6,500. We are also asking the defendant do not drive a vehicle until he has a valid license issued by DDS that is not suspended, and also has all of his tag information up to date. Finally, we're asking that he consume no alcohol or any drugs or possess any weapons during this time. Thank you.
Thank you. Mr. Chada?
Yes, good afternoon, Your Honor.
Good afternoon.
Your Honor, we asked, as you can heard from the state, he has one prior, that is the extent of his history. He is gainfully employed. Instead of focusing on the case, I'll focus on the Ayala factors. Today, you can see his brother, Mr. Hale, Donald Hale, is on the Zoom call to show support. He has very strong ties to the community. He's gainfully employed. He works for the post office. He is a lifelong resident of Georgia, Your Honor. Very strong ties to the community. It's not a flight risk. We ask that you grant them a bond in the amount of $500 for DUI less safe, $500 for the obstruction, leave the other ones as they are, for a total, I think if my math is correct, about $1,370 total bond. We can even make it a cash only bond. That way he'll post that money, and if whenever we end up resolving this case, we can use that to pay any fines. That's the amount, that's the extent of money he has to post a bond right now, Your Honor. And we'd rather not have to go through a bonding company. That way that money doesn't get lost. Again, it can be used to pay the fine when it's done. He's represented. I'm going to handle this case. The case in Sandy Springs, there's some issues with that case. We are fighting that case. His license is valid. I do know the, apologize, let me step out. I apologize, Your Honor. I am on trial, so I had to step out real quick to do this, and they could hear me in the courtroom. They are. He should be able. We are. I'm working with him on the case in Sandy Springs. I know the state asked for him to not be allowed to drive without a license. He has a valid license. He has not lost his license. We will make sure that he does not operate any car that does not have a valid registration. That is going to be taken care of as soon as he's released. His brother is actually going to handle that. So again, we ask for a reasonable bond of $500 on each of the counts, and the I think from the jail screen I can see that he already has a bond on the other ones. Let me see. I'm trying to get to it, Your Honor. Apologies. Just a second, Your Honor. I think he has on the driving an expired license, $125, and on improper lane, $265. So he asked for those to be left the same and not $1,000 to that. So he's able to bond himself out and start working on his recovery, Your Honor. There's some issues that we need to address, and he'll start working on that as soon as he's released, Your Honor. Thank you.
Okay, for the DUI, it's gonna be a $1,500 good bond. For the obstruction, a $500 good bond. For the two other counts, $250 good bond altogether. So it's gonna be a total of a $2,500 good bond, no drugs, alcohol, or weapons while out on bond. Okay?
Thank you, Your Honor. This concludes my business with the court. May I be excused?
Yes, have a good day.
Thank you. Have a great day.
You too.
Good luck to you both, Mr. Hales. Okay? What do we have next?
Position number 24, with private attorney in courtroom number 3, please.
Your Honor, just to help things along, can we also announce the name of the defendant?
Yes, it's Miss Reese, position number 24. Miss Reese has, let me see where she is. Oh, there we go. Miss Reese has already been advised of the charge against her. We were waiting. Let's see who's presenting, and it's my understanding that we've already gone through her arrest history. You want to go through that again since counsel is here, Mr. Howard, please?
Yeah, third arrest. Last arrest was in November, Dunwoody, theft of services, felony obstruction, disorderly conduct that appears to be open. 2018 hit and run, dismissed.
Okay, Ms. Lewis, good afternoon.
Good afternoon, Your Honor. So this incident occurred on January 21st at 4700 Riverview Road, where officers responded to a domestic dispute call and met with Mr. Michael Johnson. Johnson stated that he and his wife Reese have been separated for the past 6 months when she showed up at his home unannounced. Johnson also stated that Reese barged in and began collecting some items. Johnson stated that he attempted to stop her when Reese pushed past him, and as he turned, she struck him in the face. The officer observed a clear and distinct red mark on the right side of Johnson's face. We were able to speak with Mr. Johnson this morning, and he stated that he and the defendant are in the process of getting a divorce. They share 2 children, and that there is an undergoing order stating that she's not to return to the residence. This order was put in place on January 25th, and since that time, she's returned back to the property 4 times. The order also stated that she's to undergo a mental health evaluation. Mr. Johnson wants nothing to do with her and is planning to file a TPO today. And I believe he is on the call, Your Honor. For these reasons, the state is recommending a $3,000 surety bond, no alcohol, drugs, or weapons, to stay away from 4700 Riverview Road, no further contact with Mr. Johnson, 1-day anger awareness, and mental health evaluation. Nothing further, Your Honor.
Okay. Counsel in courtroom 3.
Good afternoon, Your Honor.
Good afternoon.
Ms. Reese does have a place to live that would be in the Highlands area. The address I have for that is 861 Charles Allen. It is Atlanta, Georgia 30306. We certainly understand that there's not to be any contact with Mr. Johnson at this point. It would be a condition of her bond in this case. I am not involved in the divorce situation yet, but I need to find out what those orders say in order to properly advise my client. But she understands that she's not allowed to have any contact whatsoever as it relates to Mr. Johnson and the children other than through their divorce attorneys. She does have the ability to work, and we'd ask that you give her a signature bond, Judge.
All right. Good afternoon, Mr. Johnson. This is your opportunity to address the court if you choose to do so. Of course, you don't have to, but if you would like to do so, I'll have to swear you in.
I can address the court.
Okay, it's up to you, Mr. Johnson. If you would like to address the court, you need to raise your right hand for me.
Okay.
Okay, I'll
Okay, do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, what would you like to tell the court?
We got the order in January of 2022 and nothing seems to keep her away from the house. She came to the house and she tried to get the kids to go with her on Saturday. I currently have full custody of the kids and I have pending a drug test. And that's a judge from Judge Newkirk gave us that order back in January of 2022. It's been in effect since then. And that's all I have to say. And I mean, she pushed her way into the house and hit me in the face and right in front of the kids. The kids were right there, one room away. They heard everything. And it was a bad situation. It was right before he was going to have a birthday party. It was an hour before his birthday party at the house. All this happened. So it had a huge effect on the kids. And that's all I have to say.
Thank you, Mr. Johnson. It's going to be a $3,000 good bond, no further contact with Michael Johnson, stay away from the 4700 Riverview Road address, and no drugs, alcohol, weapons while out on bond. Just so that this court is clear, Ms. Reese, what stay away means. And no further contact. No further contact means absolutely no contact. No contact by phone, no contact by personal for sure, no contact by Facebook, no contact over the internet, no contact whatsoever. I am not, and if there is an order that's already in place as far as child visitation, then whatever is in that underlying order, you'll have to abide by. All right, nothing further. Good luck to you all. Thank you.
Thank you, Your Honor.
Who do we have next?
Petition number 9.
Let's see. Good afternoon, Ms. Doubleday. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Ms. Doubleday, you've been charged in case 23CR000408D with driving under the influence of alcohol, less safe, defective or no tail lights, and operating without license required by law. Is there a history, Mr. Hilliard?
No. First arrest.
Okay. Mr. Abdullah.
Yes, Your Honor. The facts show that on January, it looks like it was the 21st, the defendant was traveling down Atlanta Street with no headlights or tail lights. Officers conducted a traffic stop and could smell a strong odor of alcohol coming from the vehicle. The defendant told officers her and the passenger were just leaving a restaurant nearby. The defendant admitted to officers that she drank 2 alcoholic beverages. During a field sobriety test, the defendant struggled to keep her balance and blew a 0.77 in the preliminary breath test. At this time, the state is recommending a $3,000 surety bond as to the DUI less safe, $500 surety bond for no tail lights, and $500 surety bond for no headlights, for a total of $4,000 surety bond. No weapons, drugs, or alcohol while on bond. That's all for the state.
Thank you. Afternoon, counsel. How are you today?
Judge Morrow, it's good to see you. For the
As
record,
always.
I'm Ray Giudice representing Ms. Doubleday. No criminal history at all, no accident in this matter, no problems with the officer, straightforward arrest. She resides with her family in Alpharetta. She is gainfully employed as a medical esthetician at Medical Wellness Spa in North Fulton. She's a post-year high school graduate in Metro Atlanta, lived in Atlanta all her life, valid Georgia driver's license. There was insurance on the car. I'd ask for a $1,500 bond on the DUI, $250 on each of the 2 light violations, which may in fact be duplicitous, but we'll get to that point later on in the case.
Are you asking for a good bond or a signature bond?
I love a signature bond, Judge. I think she'd be a great candidate for it.
Okay.
Your Honor, this
Yes.
officer Nars Corporal too. She has her father's here, and he wants to say something on her behalf.
Okay, if you want to bring him up, thank you, Norris. Yes, good afternoon, sir. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, you can put your hand down. State your name for the record, please.
Gene Doubleday.
And what would you like to tell the court?
I just want to say that Haley's a very conscientious young lady. She made a mistake, and I'm sure she'll get past this. And appreciate the leniency of the court and understand. Thank you, sir.
All right, thank you, sir. For the DUI, it's going to be a $1,500 SOB through the jail. For each of the other charges, a $250 SOB through the jail. Makes for a total of a $2,000 SOB through the jail. No drugs, alcohol, or weapons while out on bond. All right, good luck to you, Ms. Doubleday.
Thank you, Judge.
You're welcome. Y'all have a good afternoon.
That's everything done. That's what we do the jail.
Who do we have next?
Position 15 and 16, Judge. Thank y'all. Have a good day. Okay. Bye-bye.
Good afternoon, Ms. Jenkins. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you, Ms. Jenkins. She gave me the thumbs up. Ms. Jenkins, you've been charged in case 23 CR 000-412Y with battery, family violence, and cruelty to children in the 3rd degree, and in case 23 CR 000-413Y with willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
First arrest.
Okay. Mr. Abdullah.
On November 12, 2021, officers were dispatched to 5675 Roswell Road in reference to a domestic dispute. Upon arrival, officers met with the victim, Arcero Wiggins, who told them that he had been punched in the face by the mother of his child, the defendant. Mr. Arcero reported that the defendant came over to drop their child off, and he purposely kept his distance from her because he knows her to be confrontational. When the defendant got out of the car, she began cursing and screaming for profanities at Mr. Wiggins. So he walked back to his apartment. The defendant followed Mr. Wiggins back to his apartment door and handed him their 8-month child. While Mr. Wiggins was holding the baby, the defendant punched him in the mouth with a closed fist. Mr. Wiggins immediately turned around and retreated into the apartment for the safety of their child, at which time the defendant threw a diaper bag at his back. Mr. Wiggins suffered from a swelling and a laceration on his bottom lip. The defendant fled the scene. As to the willful obstruction, are we addressing both cases, Your Honor?
Yes.
Okay, as for the willful obstruction, officers attempted to place the victim under arrest for the outstanding warrant on the above case. The defendant refused the officer's command to place her hands behind her back to be cuffed after being asked several times. Officers had to perform an armbar takedown in order to get the defendant cuffed. At this time, the state is requesting a $3,000 surety bond as to the battery charge, a $1,000 surety bond for the cruelty to children, no further contact with the victim, Arcero Wiggins, a stay away from 5675 Roswell Road, third-party transfer for the minor child, 1-day anger awareness course, no weapons, drugs, or alcohol while on bond. And as for the obstruction, the state is recommending a $2,000 signature through pretrial.
The obstruction, were they executing the warrant for the battery charges?
Yes.
Okay. Yes, Mr. Edie.
Yes, Your Honor. I would be kind enough to say that would be somewhat set of a reasonable bond. I would ask that the bond total not to exceed 2,500. She do have 2 minor childs that she provides for. She does not have a criminal background here. My understanding is speaking with the family prior to being retained on this case is the facts tend to be very different here. But that would be something that would come out later down the line. But my understanding is that she was actually leaving the home when the confrontation or somewhat happened that way. So we would cease to you to let you know that she was not the aggressor in that case, and we stand by that. But we ask ultimately that she be allowed to get out, continue work to provide for our 2 minor children, and that a bond that the reason why I asked for nothing to exceed $2,500 is because I have actually spoken to the family who are on board and ready to pay that amount there for a bond right now. So what I would ask for is that to be set at no higher than $2,500, so that way she can move forward and get retained and get put out and be able to provide for her children as soon as possible.
She has no need to go back to the Roswell Road address, Mr. Ely.
Actually, Your Honor, if that's the case, you could actually ask her that, because I don't know what situation. This is the old 2021 case. I don't know what they have set and planned as far as her stay and who stays at the house and everything like that.
Okay, well, I'm going to order that she not go back to the Roswell Road address. I'm just wondering if I need to have her go back, give her the opportunity to go back on one occasion with law enforcement to retrieve any belongings that she might have there. Ms. Jenkins, do you have a need to go back to the 5675 Roswell Road address?
No, he doesn't live at that location anymore.
Okay. So with all that said, for the battery, it's going to be a $3,000 signature bond through pretrial per the judge. For the cruelty to children, it's going to be a $1,000 signature bond through pretrial per the judge. It makes it a total of a $4,000 signature bond through pretrial per the judge. 1 day anger awareness, no further contact with Mr. Wiggins. Stay away from Mr. Wiggins's residence. Also stay away from the Roswell Road address. A third-party transfer of any minor children, no drugs, alcohol, weapons while out on bond. For the willful obstruction, a $2,000 signature bond through pretrial. No drugs, alcohol, weapons while out on bond. All right, good luck to you, Ms. Jenkins.
Thank you, Your Honor. May I be excused?
Yes, have a good afternoon, Mr. Eady.
Pleasure seeing you.
Who do we have next?
Judge, we can go back to Alpharetta Jail, please.
Okay, who do we have at the Alpharetta Jail?
Thomas Miller.
Okay.
The birthday might be wrong, Your Honor.
Number is up.
Okay, I don't have a Miller on my.
Your Honor, Thomas Miller is my case. I am not sure how he got left off the calendar, but his case number is 23 CR 000436E. He was charged with giving false information to law enforcement officers. And I can, if Mr. Howard doesn't have his file, I can go over his history and this current charge.
Okay, thank you, Ms. Falk. And the name is Thomas Miller?
Thomas Bruce Miller, Miller. So common spelling on Thomas and Miller.
Good afternoon, Mr. Miller. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Miller?
Yes, sir.
Okay, did you hear my question?
No, Your Honor.
Okay, we're doing this by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Okay, you've been charged in case 23 CR 000436E with giving false information. Is Mr. Howard, I take it that you did not pull Mr. Miller's info, is that right?
Yeah, I got it. It's just not on the calendar. That's what threw me off. Second arrest, last arrest was in July out of Alpharetta for misdemeanor terrorist threats. I don't have a case number for them.
I do not either. So I'm not sure what that case number is because I don't have it at this time either.
Okay, do we know if that is that an open case? We don't know.
Your Honor.
Hold on, Your Honor, I can answer that. I'm looking at his history right now. It was given a 22 CP number. He received a pretrial release on that. And currently, let me look at it looks like he was as I said, released on pretrial release. I'm just trying to figure out what happened after that release on that 22 CR case, 22 CP case. Excuse me.
And good afternoon, Ms. Kim. Is this your case?
Yes, Your Honor, this is my case.
Okay, thank you.
That's also position 20. He's AKA known as Jesse Lowe.
Jesse Lowe. Okay, yeah.
Okay. That case is still open, Your Honor, the 22 CP 210942 case.
So he's still out on pretrial? Because I don't have that.
According to, let me just pull up the conditions of his bond. But yes, according to the jail screen, he was given pretrial release on this case.
Let me take a peek.
In the meantime, Your Honor, do you mind if I tell you about the facts of this case?
Yes, thank you.
On that. Okay, so the facts of this case are, it's pretty straightforward. Yesterday, July 22nd of 2022, the defendant officers were dispatched to a person who was intoxicated. They spoke to the defendant. The defendant used the identification of Jesse Lowe to identify himself when questioned by police. The officer took out a warrant for this on October 11th of 2022. So essentially, once they realized he was not in fact Jesse Lowe and his actual name was Thomas Bruce Miller, the officer went ahead and took out a warrant for giving false information to law enforcement, which then led to this arrest. And so it all appears to stem back from that previous case where he was given a UJR and given pretrial level 2. And I'm looking at that. It looks like that was given by Judge Elizabeth George on July 25th of 2022. So essentially the reason he's here now is because he gave a false name then, which then triggered all of this.
Okay, what's your recommendation?
State's recommendation on this is going to be $1,000 surety bond, no alcohol, drugs, or weapons. I will say to Mr. Howard with pretrial, I don't believe he can necessarily be revoked on pretrial based on this because it happened concurrent to his terroristic threats case. So we will refer this up so that the DA's office can take it along with the terroristic threats case that he has pending upstairs in the DA's office.
Okay.
Said they happened at the same time?
Yeah, essentially he was arrested as Jesse Lowe on that terroristic threats because he gave a false name to police when he was arrested.
Your Honor.
Hold on, Mr. Lowe. I see you there. I'm going to get to you. Okay, so just hold on for me.
Okay, sorry, Your Honor.
No, you're fine. Just give me I saw you there, so just give me a minute, okay?
Thank you.
You're welcome. Anything further, Ms. Falk?
Nothing further, but I am very interested to hear what Mr. Jesse Lowe, who appears to be here as the victim in this case, has to say about this matter.
Well, I think we all are. Ms. Kim, do you want me to speak with Ms. Lowe first? Mr. Lowe
Yes,
first?
Your Honor.
Okay. All right, Mr. Lowe, you're going to have to get yourself to a steady place for me so you can address the court, okay?
Yes, sir. I'm sorry. I was shooing some kids away. I didn't know if this court was for me or for Miller or for...
Okay, hold on. Raise your right hand for me, okay? Do you swear affirm the testimony you're about to give before this court, be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand out. Now, are you are Jesse Lowe?
I'm Jesse Lowe. Yes, sir.
Okay, and do you know Thomas Miller?
Yes, sir.
Okay, and what do you want to tell the court about this?
Well, it's not his terroristic threat charge. It's mine. And it happened at Rumi's kitchen where me and Miller
Okay,
met.
hold on, Mr. Lowe. Since you're telling me that, let me just tell you, you have a right to remain silent, and anything you say can be used against you. I don't want you to say anything that might incriminate you because we are live on YouTube, and anything that you say can be used against you in that other case. But so you're telling me that you're Jesse Lowe and that Mr. Miller here is not Jesse Lowe. We'll get all the other things straightened out in time, okay? Do you have something that you want to tell me that has to do with Thomas Miller allegedly using the name of Jesse Lowe?
No, Your Honor. I just had a question because my charge turned into a felony, and he saw the judge under my name, and the judge looked at him and made it a felony. So I just wanted to make sure that that I had a fair chance of seeing the judge and him keeping it a misdemeanor or bringing it up to a felony, but he thought he talked to me, but he didn't talk to me. He talked to Miller.
Okay, so you're gonna have to talk with the district attorney about that, Mr. Lowe. I'm not sure.
Is that okay for me to do, to talk to a DA?
Do you have a lawyer?
No, Your Honor. I did talk to the head public defender, Elizabeth, about it. But it's,
So
I've been very.
why don't you do this, Mr. Lowe?
Yes, sir.
Why don't you get in touch with the public defender's office and see if you qualify for the services of a public defender? Okay, if you qualify, then they'll represent you going forward, okay?
Will I have a fair chance to see the judge, Your Honor, originally, like be arraigned? I've never been arraigned for this charge, and I'm in court right now, but I've never been arraigned for the charge he was. So I want to be arraigned and have a fair chance of being arraigned.
So
it doesn't seem fair.
The first thing I want you to do, or that I would suggest that you do, is get in touch with a public defender. Ms. Melnick, are you there with me?
Yes, Your Honor. I'll,
Can you give, put it into the chat, your number or someone's number so that Mr. Lowe can make application with you all to see if he qualifies?
yes, Your Honor.
Okay.
And
So,
Your Honor, if I may request that Ms. Melnick reach out to me, because this is so tangled at this point. I am trying to figure out if there is maybe, I'm not sure if this is an identity fraud. I'm not sure what's going on, but if Ms. Melnick, after speaking with Mr. Lowe, could reach out to me, so maybe we can help untangle this a little and figure out if we need to be charging Mr. Miller with, essentially just figure out who's who.
Right. Mr. Lowe, can you put your name and or just put your cell phone number in the text or the chat text, and as soon as court's over, I'll contact you.
Absolutely.
And just I'll say another word, please.
You said don't say another word?
Yes.
Okay, I'll mute myself. Thank you.
Thank you.
all right, very good.
Oh,
Thank you, Ms. Melnick. And Ms. Kim, I would have gotten you to do that.
Can
for
I
me,
be
but,
dismissed?
Yes, you're fine. No, well, make sure you put your information in first, Mr. Lowe, and so that Ms. Melnick can get in touch with you. So
Thank you.
You're welcome. Back to you, Ms. Kim. I want Ms. Melnick to do that since you're representing Mr. Miller here. So
sure.
And
I want to chime in when you get a chance.
you want what?
I want to chime in when I can. This is
Okay, well,
making my
why
head hurt.
don't you chime in right now?
All right, so the terroristic threats was, the defendant that's here now was the one with the terroristic threats. I'm looking at the booking sheet. So he's the one for both of these arrests. And y'all saying he's not Lowe, he's Miller? Because I'm about to revoke this pretrial bond. It's the same defendant for both, so he about to sit until he go to court for this.
All right,
Whatever name he used.
Let's just figure this out at another time, Mr. Howard, because we've got representation that Mr. Miller, who is sitting in the orange jumpsuit, is not Mr. Lowe. And so we're gonna have to figure out who's who. Ms. Kim?
Yes, Your Honor.
Yes, anything from you?
Since we represent Mr. Miller, I have a strong feeling that Mr. Jesse Lowe have to be represented by a conflict attorney. And yet Thomas Miller, he claims that the officer arrested a wrong guy. He is a wrong person that was arrested for this case. He is actually 20 years old. Unlike Mr. Jesse Lowe, who is 27 years old, he has completely different birthday, completely different address where he resides, and his job is he's gainfully employed at AT&T as a sales representative. He's been working there for a few months. He has an associate degree from Georgia Tech, and he worked at restaurant. All those histories are completely different from Mr. Lowe Jesse as well. Lowe Jesse worked at the Rays on Cedar Creek, which is different job. My client, Mr. Thomas Miller, is not qualified for public defender's service because he's gainfully employed. We would like to make sure he gets a fair chance. After today's bond hearing, we're not going to be representing. However, I want him to get a signature on bond and get back to wherever he has to go back for his work and everything else, because he is surely not the person who did anything here.
All right, so you all gonna need to sort this out. It's gonna be $1,000 signature bond through the jail, no drugs, alcohol, weapons while out on bond. Okay. If nothing further, good luck to you, Mr. Miller, Mr. Lang.
Thank you, Your Honor.
All right, who do we have next?
Position 5, Buford.
Good afternoon, Mr. Buford. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Buford, you've been charged in case 23 CR 000439F with criminal trespass and damage to property, simple assault, terroristic threats and acts, disorderly conduct, public drunk, and willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
Yeah, I know, Shelley. I caught that. Judge, he got 93 total. Last arrest was in November. Felony shoplifting, June. Misdemeanor shoplifting and obstruction. May, failure to appear for theft by taking possession of drug-related objects. 2021 FTA, shoplifting. Theft by taking conviction from 2021. 2021 shoplifting. It's a lot of shoplifting, probations, and trespass.
Okay.
But he's on probation for shoplifting. I meant theft by taking out of state court. On probation in DeKalb, felony shoplifting.
Is there anything in the history regarding any violence?
This is the last file I got. This is the add-on. Not in the last 8 years at least. I can tell you that. Because most of it is theft and probation. I'm in 2013 now, so no, not in the last 10 years at least.
All right, thank you. Ms. Lewis?
Yes, Your Honor. This case or this incident occurred on January 21st, 2023 at 639 Morosco Drive. The officer responded to a trespasser at the above location, which is a Chevron gas station, and spoke with the store clerk, Ms. Stefani, and that's spelled Sefeni. The police report did not have a first name listed for this witness. Stefani stated that a known shoplifter, who is known as Buford, had been issued several trespass warnings and came into the location again and began to steal merchandise and knock over aisles of merchandise. Stefani said that when she confronted Buford, he approached her aggressively and banged on the glass window, which separates the clerk from the customers. The officer stated that, Officer Petkoff stated that he is familiar with Buford and he has been the responding officer for this area for the last 2 years. Buford is a known nuisance around the Lindbergh Drive and Piedmont Road area. When Officer Petkoff detained Buford, he had an open alcohol container that was half consumed, and he could smell alcohol beverage coming from his breath. Petkoff stated that as he was transporting Buford to the jail, Buford repeatedly yelled obscenities and profanities at him and began spitting at him. At one point, the officer said he could feel some spit land on his neck and behind his head. Once at the Fulton County Jail, the officer placed a spit mask on Buford, to which he removed, and then Buford also made an aggressive stance towards Officer Petkoff. Officer Petkoff stated in his report that he believes that Buford does not take the criminal justice system seriously because during his arrest, he stated that he would be out within a day. Your Honor, as Mr. Howard stated, this defendant has an extensive history of criminal trespassing as well as theft by shoplifting. And for this reason, the state is recommending a total $3,000 surety bond. That's $500 for each count. Stay away from the Chevron gas station on 639 Morosco Drive, and no alcohol, drugs, or weapons. Nothing further, Your Honor.
Okay. Ms. Kent?
Yes, Your Honor. Tony Buford is 57 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here, but no resources to assist with bond. Mr. Buford completed the 11th grade and he is currently employed in a temporary capacity. He only works part-time. He strongly denies the allegations. He does not have any recent convictions for violence. We are requesting a signature bond on Mr. Buford's behalf, and we are unopposed to any stay-away conditions. And if Your Honor determines that he's ineligible, we would ask for a total bond of no more than $1,500, and that would be $250 for each count. Thank you.
So for the simple assault, it's going to be a $500 good bond. For the terroristic threats, it's going to be a $500 good bond. For the other 4 charges, it's going to be a $250 good bond. That makes for a total of a $2,000 good bond. No drugs, alcohol, weapons while out on bond. Stay away from 639 Morosco Drive, and no further contact with the alleged victim, Mr. Safani. All right, good luck to you, Mr. Buford.
Judge, what was that total?
2,000.
2,000.
Thank you, Your Honor.
You're welcome. Who do we have next?
Position 7, Carr.
Good afternoon, Mr. Carr. I'm Judge Eric Mara. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. Mr. Carr, you've been charged in case 23 CR 000430F with battery family violence. Is there a history, Mr. Howard?
I got first arrest for Miles Carter.
Okay, Mr. Rogers.
Yes, Your Honor, for this incident on January the 22nd of 2023, Amina King contacted police. They arrived at 404 Dixie Hill Circle in reference to a domestic dispute. Ms. King did report to police that Miles Carr did throw multiple punches at her while she was attempting to enter the kitchen. Mr. Carr and the victim, Ms. King, they do share a pad split type home where they occupy separate rooms, but they share the common areas. She stated that she barely knows Mr. Carr and that basically he just randomly attacked her. She stated her face is pretty injured and that she will send pictures over. She does not want any contact with Mr. Carr. For that reason, we're asking for a $5,000 surety bond, no further contact with the victim, and a stay away order from the address of 404 Dixie Hill Circle. That's all, Your Honor.
Mr. Bradley?
Yes, Your Honor. Thank you. So Judge, Mr. Carr is 24 years old. He's completed 2 years of college at the University of Alabama. He's originally from Alabama. He moved here and he's been staying with the alleged victim in this case. They shared that living arrangement while he worked here. He works for a valet company here. He does have family here, but his mom and dad live in Birmingham, Alabama. Judge, he's gainfully employed. We're asking for a $2,000 signature bond. I've spoken to his father, and they have secured other living arrangements for him where he can stay. And so he would probably need a one-time order to go back in order to get his property. But outside of that, they've secured living arrangements for him so that he can still be able to work and live here. And so we're asking for a $2,000 signature bond at the jail to sign out. He does not have any history. I can't tell you what happened that sparked this, but this is not in his character. I've known his dad for a long time. And I don't know what actually sparked this, but I think a $2,000 signature bond through the jail is reasonable in this case.
Okay. It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further contact with Ms. King, stay away from the Dixie Hill Circle address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there, drugs, alcohol, or weapons while out on bond. Okay. Good luck to you, Mr. Carr. Anything further this afternoon, Mr. Bradley?
No, Judge.
Okay. Have a good afternoon.
Position 32, Wilson.
Good afternoon, Mr. Wilson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Wilson, you've been charged in case 23 CR 000435C with battery family violence. Is there a history, Mr. Howard?
Last arrest was on the 19th of this month. I guess it was at the city jail. You went to misdemeanor possession of marijuana. 2017, possession of cocaine, sale of marijuana, possession of a knife or a firearm during a commission. 2 counts given false name conviction, 2010. 2010 ag assault, possession of a knife or a firearm during a commission. Possession of a firearm by a convicted felon, a felony first offender conviction. That's 10 SC 88399. You want me to keep going?
You're good. Thank you. Who's presenting for the state?
It's me, Your Honor.
Yes, Ms. Bach.
Yes, Your Honor. This happened back on September 13th of 2022. Officers responded to 15 Oak Drive in reference to a assault. They spoke with Miss Eureka Jones, that is EUKEERIA Jones, who stated that she was walking home and some individuals got out of a vehicle and jumped her. She stated it was 2 females. When she went home, she stated that she talked to the defendant, who's the father of her child, and told him what had occurred. She stated at that point, Mr. Wilson became irate and then assaulted her. Officers could observe visible bruising to her right eye. They actually took a photo of it with, they took documented on their body worn camera. What's of particular note in this case is there were 2 witnesses to this, Miss Lamantia Williams and Miss Esther Williams, who both stated they had to physically pull the defendant off of Miss Jones while he was assaulting her. So for that reason, we do have some serious concerns in regards to this case. As far as victim contact is concerned, just give me a moment, Your Honor. In this case, we did attempt to call the victim. We were unable to leave a message due to the mailbox being full, and we did send a text. So the state would ask that we sound for the victim in this case. I will state that the defendant has a lengthy history. The state is concerned due to some of the violence in the history, and we are requesting a $5,000 surety bond, that the defendant stay away from 15 Oak Drive, and that he have no further contact with Miss Jones. We are further asking that he have no alcohol, drugs, or weapons. Thank you.
Thank you. Is Miss Eucuria Jones on the line? Doesn't appear so, Ms. Falk. Ms. Kim?
Yes, Your Honor. Mr. Larry Wilson is 49 years old, and he was born and raised here in Georgia. He has a strong ties to the community. He is gainfully employed at Crew One Production. They organize different concerts as a contractor. Before doing that, he also worked at repairing houses in Alabama, and also he graduated from high school here in Georgia. He's father of 3 minor children. One of them is a child with Miss alleged complaining witness, Miss Jones, and also 2 other children that he has a full custody, 8 and 13 years old. He is currently in wheelchair. He's partially paralyzed, so he's having some difficulties in terms of moving and mobility. We would like to request for a signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we would like to request for the maximum $1,000 good bond. Thank you.
All right, it's gonna be a $3,000 good bond, no further contact with Ms. Jones, stay away from the Oak Drive address, third-party transfer of any minor children, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Wilson. Your client has his hand up, Ms. Kim.
Mr. Wilson, I'll be happy to call you to explain anything and everything. You have a right to remain silent, so please do not speak anything, especially the facts of the case.
We stay together.
Who do we have next?
Position number 12, please.
Okay. Good afternoon, Ms. Hessler. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Ms. Hessler, you've been charged in case 23 CR 000409D with battery family violence. Is there a history, Mr. Howard?
I got first arrest.
Okay. Mr. Abdullah, is this your case? You are mute if this is.
I'm sorry, Your Honor. The facts will show on January 22nd, 2023, officers responded to a physical domestic dispute at 240 Back T Court. Upon arrival, they met with the defendant, who was on the porch smoking a cigarette and drinking a beer. The defendant told officers she was upset and arguing with her son, the victim, Winston Hessler, because she wanted him to help out around the house. Mr. Hessler told officers that the defendant had been drinking and screaming at him all morning. And as he left the house to throw away the trash, the defendant struck him in the face with an ashtray. Officers observed a laceration and bleeding above Mr. Hessler's eye, as well as cigarette ashes on his shirt. Although the defendant does not have a lengthy arrest record or an arrest record at all, we've spoken to the victim. He's let us know that this is not the first time that the victim has been violent with him or assaulted him. He says that it's very common that when she drinks, she can't control her anger. She's been put out of several hospitals as well as several stores and pharmacies because of her drinking. A few years ago, she went through rehab and she did improve. Her anger did improve and she was doing pretty good, but it seems she's relapsed. And since then, she's been having these violent outbreaks pretty recent. Also, due to her close family relationship with the defendant, there's a likelihood that she could influence the victim not to cooperate with the prosecution of this case. For those reasons, we're requesting a $3,000 surety bond, no further violent contact with the victim, Winston Hessler, a one-day anger awareness course, and no weapons, drugs, or alcohol while on bond.
Ms. Gant?
Thank you, Your Honor. Ms. Sandra Hessler is 62 years old. She has been in the Atlanta, Georgia area since 1993. She is widowed and has 4 children, including Mr. Hessler. None of her children are minors, Your Honor. Ms. Hessler earned a bachelor's degree in civil engineering. However, she spent most of her life at home as a stay-at-home mother. She is the owner of she states that she purchased the property at the incident location back in 2021, and that she invited Mr. Hessler, her son, to move in with her because he needed some assistance. She strongly denies the allegations, Your Honor. I am requesting a signature bond on Ms. Hessler's behalf. She's not on trial today regarding her alleged alcohol use, Your Honor. And I would just ask that you focus on the fact that she's never been arrested for any violence. She's 62 years old. I did speak to her son, Mr. Hessler. He informed me that he does want to have contact with his mother, as does my client. I believe that he is on the line. I did send him the Zoom link, Your Honor. We're requesting a signature bond. We are opposed to the no violent contact. We are unopposed to the no violent contact orders and ask that Your Honor not put in place a stay away. Thank you.
All right, it's gonna be a $3,000 signature bond through pretrial per the judge, 1-day anger awareness, no further violent contact with Mr. Winston Hessler, and no drugs, alcohol, weapons while out on bond. Good luck, Ms. Hessler.
Thank you, Your
Thank
Honor.
you. Position 21.
Oh, go ahead, Sarge.
Thank you. Position 21, please.
Okay.
It's gonna be a minute.
Good afternoon, Ms. Moore. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Yes? Okay, thank you, Ms. Moore. You've been charged in case 23 CR 000420J with battery family violence. Is there a history, Mr. Howard?
So fourth arrest. Previous 3 come out of Kentucky. 2016, it's a bench warrant. It says failure of owner to maintain required insurance. That was a conviction. I see assault 4th degree conviction from 2011. And a 2011 instructional permit violation. That's all. Nope, I'm sorry. 2020 out of Georgia, simple battery, 2 counts. That was dismissed though, out of Cobb County.
Okay, Ms. Lewis.
Yes, Your Honor. This incident occurred January 22nd at 1925 Monroe Drive, apartment 1643. Officers responded to a domestic dispute call and met with Charity Moore and Daryl Woodard. Woodard stated that Moore was preparing to leave his apartment when he was in the shower. He then heard a knock on the door and noticed Moore trying to regain entry into the apartment. An altercation began because Woodard stated he told Moore that he wanted the key to his apartment back. During this altercation, Woodard stated that a few locks of his hair were pulled from his scalp, and Moore began to damage the apartment. Woodard also stated that in a previous altercation, Moore stole his wallet. We were able to speak with Mr. Moore this morning, and he stated that him and the defendant used to date, but they are now just friends and they no longer live together. He also stated that he's not in fear of the defendant, and I believe he's on Zoom right now. Your Honor, the state is recommending a $5,000 surety bond, no further contact, 1-day anger awareness to stay away from this location. And that location was 1925 Monroe Drive, and no alcohol, drugs, or weapons.
Okay, Ms. Melnick.
Did you want to hear from the victim first, or the complaining witness first, Your Honor?
Is Mr. Woodard on the line? Mr. Woodard, this is your opportunity to address the court if you choose to do so. Doesn't appear so, Ms. Melnick.
Yes, Your Honor. I do want to allege a few more of the facts that were omitted from the arrest warrant, Your Honor. It states that Ms. Moore was initially moving out of the apartment. She had left, and then she only came back to grab one more thing. Also, it was left out that the complaining witness grabbed his firearm and was waving it at her. The report also states that both parties had bruises and scars, and they did not arrest him. They only arrested her because they said she came back, and that made her the primary witness, the primary aggressor. I feel like this is with him waving the gun. And he said that he is not scared of her. Of course he's not, he has a gun. So with her limited record, she is a substitute teacher. She does have a colleague that she can go and work for. So we're asking for a $3,500 signature bond.
I'm here, Your Honor.
Okay, you are Mr. Woodard?
Yes, I am.
Okay, can you activate your camera for me, Mr. Woodard?
I've been trying to do it, but for some reason,
Your Honor, I'm going to object to any comments if he cannot have his camera on.
Okay.
We have a right to confront him.
I'm going to give him the opportunity to see if he can, Ms. Melnick.
That's fine, Your Honor.
Okay. So, Mr. Woodard, you might have to log out and log back in to see if you can get the camera activated. What does it say there?
It has my picture up, but it's not, when I go back to the icon, it's just showing black still.
Okay, do you want to try logging out and logging back into the session?
Yeah, sure, hold on 1 second.
Okay. Do we know if he's logging back in, Ms. Grace?
Yes, he is, Judge.
Okay, thank you. Good afternoon.
How are you?
Fine, thank you. All right, there you go, Mr. Woodard. Can you unmute yourself for me? All right, raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. What would you like to tell the court, sir?
I never pointed a gun at her. I am not in fear of her because I feel like she was just acting out emotionally. However, she does realize that she was wrong for what she did. I have been talking to her since she went to jail. I do feel like she has learned her lesson from this situation. No, I'm not in fear of her, but I do feel like, the truth needed to be told. I never pointed a gun at her. She never did force her way into my house, like while I was taking a shower. I don't know where that report came from, but she did steal my key, which caused a argument to start. And she knew that she was wrong for doing that. Even once the police officers got there, I told them I didn't really want her locked up, but I needed them there for my safety because I am a Black man. And she did get on the phone and tell the police that I had a gun and I was pointing. Once the police came in and they saw the damages and all of the stuff, and they gathered all of the stories, they said that they had to take her to jail. So, but I do feel like I feel like she should be able to get a signature bond, be able to get out, go to her job. She's a good person. She is a teacher. And that's all really I got to say.
Okay. Does she still have any belongings at the Monroe Drive address? Mr.
No, I actually gave her belongings to a friend, which she asked me to do. The police officer recorded it. So we took care of that earlier today.
Okay.
And that's where she's supposed to be going whenever she get out of jail, so she'll be able to have her belongings.
All right. Thank you, Mr. Woodard. It's going to be a $5,000 signature bond through the jail. No further contact with Mr. Woodard. Stay away from the Monroe Drive address. No drugs, alcohol, or weapons while out on bond. So that you understand, Ms. Moore and Mr. Woodard, no further contact means absolutely no contact. No phone contact, no internet contact, no social media contact while this is going on. While you're out on bond, there's to be no contact whatsoever. All right. Good luck to you both.
Nope.
Who do we have next?
Can we go back to Alpharetta Jail, please?
We can. Who do we have at the Alpharetta Jail? Brown. Mr. Brown. Okay.
Who you say this is?
Tell me the last name again.
Graham.
Graham?
Yes, sir.
Okay. Okay, Mr. Graham is position number 10.
Your Honor, the state would request a breakout on Keenan Graham. My apologies, I didn't get a chance to communicate with you before I got kicked out the first time.
Okay, that's fine. Who would you like in the breakout?
Whoever the public defender is.
Okay.
That would be me, Your Honor.
All right, can we put Miss Kim, Miss Falk, myself into a breakout room?
You gonna give him the history?
And put Mr. Howard in there too.
No, I was asking was she gonna give you the history? That's all.
Oh, that's fine, if Miss Falk has the history.
I do.
All right, cool. Judge, I'm gonna go to the bathroom. I'll be back.
Okay, okay, Judge.
Let me see, is Miss Kelly Kirsten in the Zoom meeting?
Yes, Your Honor.
Oh, okay. And this is you under, oh, daughter in Crimson?
Yes, sir.
Okay, I'm gonna bring you into the breakout room, okay?
Okay, sir. Thank you.
All right, so could you put myself and Miss Kirsten back into the breakout room, please?
Yes, Judge.
Thank you.
Judge, can you go to the bottom of
Yes.
your screen
Yes.
where it says breakout room
Okay.
and hit join, Mr. Jordan said. Okay.
Okay, we're back and with Mr. Keenan Graham, we've had a discussion with Ms. Falk, with his attorney, Ms. Kim, with his mom. It's going to be a $2,000 signature bond through pretrial per the judge. I want an 8-week anger awareness class, no further violent contact with his mom, Ms. Kirsten. Mr. Graham, you're going to have to continue to work towards getting your GED. You're going to have to continue to work and be productive in your job. And you're to have no drugs, alcohol, or weapons while out on bond. I'm going to give you this opportunity, Mr. Graham, based on what your lawyer has said and what your mother has said. But you're going to have to start these anger awareness classes within 2 weeks of me letting you out. Okay, you understand that?
Yes, sir. Thank you.
All right. All right, if nothing further on Mr. Graham, good luck to you, sir. And he's gonna need a co-signer, so, Mr. Howard, you got it back? Well.
Yes, I'm here.
I'm gonna weigh the utility bill, so if you can bring me that form, but he's going to, I'm gonna have, his mother sign it out.
What's her name?
Kelly, I have Kelly, Kirsten, Kierston.
Your Honor, it's Kelly, Kelli, Pearson, Pearson. I apologize for not spelling that on the record the first time.
Okay, thank you.
Spell the last name again.
Say it again?
Spell the last name again.
I have
Pearson. Yeah, sorry, go ahead, Your Honor.
Go ahead, Ms. Vaughn.
It's Pearson, Pearson.
All right. Make sure she has a valid ID.
Okay. All right, who do we have next?
Position number 17.
Okay. Good afternoon, Ms. Johnson and Mr. Derek Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Johnson, you've been charged in case 23 CR 000423F with willful obstruction of a law enforcement officer in public drunk. Is there a history?
Fifth arrest. Last arrest was on the 13th of this month out of Duluth. It's for DUI, suspended license. Before that was May 2022. DUI, suspended license, hit and run, suspended or canceled registration. June 2021, DUI, concealing the identification of a license plate. 2019, DUI, suspended license. The DUI was dismissed. The suspended license was amended to a non-fingerprintable charge. That's it.
Okay. Mr. Abdullah.
Your Honor, the facts showed that on January 21st, 2023, officers were called by security to 11505 Alpharetta Highway for an unknown person trespassing. When officers arrived, they made contact with the defendant who was sleeping on the property. Officers asked the defendant to leave and told the defendant they were issuing a trespass notice. Officers attempted to identify the defendant several times in order to issue that notice. She refused and began screaming obscenities at the officer, calling the officer retarded, excuse my language. Officers noticed a strong odor of alcohol on the defendant's breath, at which time they placed her under arrest. The defendant has a 5-cycle arrest record with all of the offenses involving alcohol. She's been arrested here in the last 2 years, 4 times for DUI. She just received a final disposition in the DUI case in which this was on January 9th. So less than 20 days ago, she just received the final disposition on the DUI case in which she was ordered by Judge Richardson to undergo alcohol drug evaluation and treatment. She has not done that yet. At this time, the state is recommending a $2,000 surety bond for the obstruction, $8,000 surety bond on the public drunkenness. a stay away from the incident location, no weapons, drugs, or alcohol. And if the defendant does bond out, we ask that you make her complete the alcohol, drug, and evaluation treatment within 30 days of release. No, nothing further from the state.
Okay, Ms. Melnick.
Yes, Your Honor. My client is unemployed, although she does work at home because she has 4 children and one of them is a disabled child. Although he is 16, still disabled, and she is primary guardian and primary caretaker for that child.
I'm sorry, I think he's talking about the wrong Johnson.
Yeah, that's the same ad now.
Yeah, there's 2 Johnsons on the calendar today.
Yes,
This
Sabrina
is,
Johnson.
no, this is not Sabrina. This is Naifield Johnson.
I am so sorry. You're so sorry.
Okay, so this is position number 17.
I'm sorry. I had Johnson written down. I do apologize, Your Honor. Okay. She lives with her aunt in Lawrenceville. She lives with her aunt in Lawrenceville. This is just simply a case where she was not driving, Your Honor. She was simply asleep at an Audi dealership. So we'd ask the court to take into consideration that the minor offenses of this and to give her a signature bond on this case. And I do apologize. There are 2 Johnsons and I have my notes are back to back.
You're fine, Ms. Melnick. Mr. Abdullah, where is the stay away from?
The
An
stay
Audi-
away, it's the Audi dealership.
Yep.
It's 11505 Alpharetta Highway.
Okay, so for the obstruction, it's going to be a $2,000 signature bond through the jail. For the public drunk, $1,000 signature bond through the jail. Makes a total of a $3,000 signature bond through the jail. She has began the ADT, which has already been ordered within 2 weeks of release, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Johnson.
Can I just add something, please?
You have a right to remain silent. Anything you say can be used against you. I've given you a signature bond, Ms. Johnson. So anything else, I recommend that you speak with your attorney regarding. But you've gotten a signature bond as it relates to these 2 charges. Okay.
Yes.
Thank you.
Okay. Who do we have next?
Position 18, Judge.
Okay. Now this is Miss Sabrina Johnson. Okay. Hi, Miss Johnson. I'm Judge Eric.
You'll know. I think you'll be able to know what I'm going to say on this one.
Okay. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Is that a yes? Okay.
Yes.
Thank you, Ms. Johnson. You've been charged in case 23 CR 0004255H with willful obstruction of a law enforcement officer, disorderly conduct, a seatbelt violation, a reckless driving, improper backing, driving under the influence of alcohol less safe, and possession of an open alcohol container. Is there a history, Mr. Howard?
14 total. Last arrest was 2014, probation. Underlying charge was ag assault. 2014, 2 counts of cruelty in the first conviction. 2011, the ag assault. Got an 09 DUI arrest. Got a DUI conviction from 2009 out of Lawrence jail. DUI conviction 2006. That was out of Lilburn. I think that's it. Everything else is like early 2000s and 90s.
Okay. Mr. Villa.
Your Honor, the facts show that on January 23rd, 2023, officers observed the defendant driving in reverse at a high rate of speed in the passing lane on Donald Lee Hollowell. The officer activated his emergency lights and the defendant continued to back past him, nearly hitting his patrol car and another vehicle in the oncoming lane. The officer was able to stop the car and speak to the defendant who was driving. Upon approaching the vehicle, the officer noticed 2 open alcohol bottles on the back seat and he also noticed the defendant was not wearing her seatbelt. The officer asked the defendant to step out of the car and asked how much she had been drinking. The defendant denied drinking, but the officer could smell alcohol on her breath. The defendant agreed to complete a field sobriety test, but was unable to complete it because she would not follow the instructions of the officer. The officer placed the victim under arrest and cuffed her arms to her back. The defendant complained of arm pain due to a surgery, so the officer uncuffed her and cuffed her arms towards the front of her body and placed her in his car. While in the car, the defendant began banging the handcuffs and her hands on the glass, trying to break it. Officers took her out of the car and recuffed her, placing her arms to the rear of her body. At that point, they attempted to put her back in the car and she refused to get in completely. She sat down in the car, but kept her legs out the car. Officers asked her several times to place her legs back into the car, which she denied. Officers had to forcibly push her body into the car so that they can close the door. The defendant has 2 prior convictions for DUI, as well as a conviction for obstruction. The defendant's 14-cycle arrest record shows a disregard for the laws of this state and the rules of the road. It's the state's interest to keep the road safe. However, that's hard to complete if we allow the defendant to get out and drive again. For that reason, we're asking for $1,000 surety bond as to count 1, obstruction, a $500 surety bond as to count 2, disorderly, a $250 surety bond as to count 3, seatbelt violation, a $1,000 surety as to count 4, reckless driving, as to count 5, a $250 surety bond for improper backing, count 6, DUI less safe, $5,000 surety bond, and count 7, open container, $500 surety bond, for a total of $8,500 surety bond. No weapons, drugs, or alcohol while on bond, and no driving. Nothing further from the state, Your Honor.
Ms. Milner?
Yes, Your Honor. As I stated earlier, sorry, that she is unemployed, but she does work from home, taking care of her minor children. She does have a disabled child, and she's primary custodian of the child, and of all 4 children. Although she is a work from home mother, any type of bond would in essence be a no bond situation from her because she does not have any extra income coming in, and it puts an special burden on the children. So given that we are, I also want to state that she also had she did end up having to go to Grady, and she did have several injuries from Grady. So she was at Grady for quite a bit. So we are asking for, if the court would be so kind, given the fact that she does have a disabled child at home, for signature bond on these cases.
Okay, I'm not inclined to give her a signature bond given her history. It's going to be a $2,000 good bond for the DUI, and it's going to be a $250 good bond for all the other charges. So my calculations has that being a total of a $3,500 good bond, no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Johnson.
Your Honor, did you didn't mention any driving privileges?
Her license is suspended.
Well, if she does not have a valid license, then she can't drive, obviously. And anything else, I'm going to leave it up to DDS. Okay.
Thank you, Your Honor.
Your client has her hand up, Ms. Melnick.
We will speak with her after court.
Okay. All right. Good luck to you, Ms. Johnson. Who do we have next?
Position number 27.
Okay. Good afternoon, Ms. White. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Ms. White, you've been charged in case 23CR000419C with simple battery. Is there a history?
Second arrest. Last was 2020 for battery out of Fairburn. Let's see, case number 22 CR 002-533C. And I see a fray in here, 22 CR 004-179C. That's it.
Is there a disposition?
According to the bond assessment is open, but I'm sure the
Okay,
state knows.
thank you. Ms. Falk? You're on mute.
I don't know everything, Your Honor, but I am showing for Miss Amisha White that she has a dormant bench warrant on both cases, the battery as well as the affray for the fighting. That was before Judge Myra Dixon, and Judge Dixon issued the bench warrant on December 12th of 2022 for her failure to appear in court on both of these charges on November 29th of 2022. So I don't believe that this will, regardless of what happens today, that will result in her release, given those outstanding bench warrants. In this case, it appears that on September 14th of 2022, the defendant was asleep at her home, received a phone call from a Mr. Bruce Jones. In regards, they ended up in an argument about why she didn't wake up when he was calling. She then got in a friend's car. Miss Bray went over to 426 West Broad Street, which is Clifton's restaurant, where she met with Mr. Bruce Jones. At that point, when they got at that location, they got into a verbal dispute about him talking to another woman. She stated to police when they interviewed her that she slapped him with an open hand, and then he struck her back, which then began a fight. After they were brought outside by other patrons of the bar, Miss White and Miss Bray, the defendant Miss Bray, attempted to leave the location. And at that point, Mr. Jones pulled a handgun and shot at their vehicle. So Mr. Jones was arrested separately for the aggravated assault. However, Miss White was arrested, or a warrant was issued for her because she admitted to police when they were interviewing her that she initiated physical violence by slapping him, which is what got everyone put out of the restaurant in the first place. The state, has some concerns because Miss White has a open affray for fighting and then an open series of battery cases, none of which involve the defendant, but still are leading for us to have some concerns in regards to this victim and kind of her part in all of this. I am by no means absolving Mr. Jones of his part of this, but I'm also acknowledging that clearly there is something going on her end too when it comes to violence. The state is requesting a $2,000 surety bond. We are requesting that she have no further contact with Mr. Bruce Jones, no alcohol, drugs, or weapons, 1 day anger awareness. We are also asking that she stay away from the location at, excuse me, I just need one moment. That she stay away from the location of the restaurant that they were at, and lost my
426 West Broad Street.
Yes, thank you. And I believe it's Clifton's is the name of the restaurant.
Okay.
And nothing further from the state. Thank you.
Ms. McLeod?
Yes, Your Honor. Good afternoon. My client, White, is 23 years old. She's a lifelong resident of the state of Georgia and the Metro Atlanta area. She is employed in housekeeping in a hotel, Your Honor. She does deny that she was the aggressor in this particular incident. And based on what the prosecution has said on the warrant itself, it seems she was a victim, actually. The warrant stated that the car she was in was shot up, and essentially there were 4 or 5 shots fired. So fortunately, she was not injured on the occasion, Your Honor. She tells me that she doesn't necessarily want to have contact with this person, and she denies that she was the one who initiated the violence, Your Honor. She doesn't have any money to pay any bond. She is presumed innocent where those other outstanding matters are concerned. And she also told me with respect to the failure to appear that she did in fact appear in court in October, and she was told that she would receive further notice, which she did not receive, and that was the reason why she did not show up and why the FTAs were issued. I don't believe that she's a flight risk at all, Your Honor, and I would ask the court to consider her circumstances on what happened and the length of time since this happened. It happened in September, and give her a signature bond so she can get out of jail and get back to her job. Nothing further, Your Honor.
And Your Honor, I will point out that the case was reset twice before a failure to appear was issued. Once in September 20th of 2022. And at that point, they said it was the first time on the calendar. They reset it again, October 18th of 2022. And it was the third time that a failure to appear was issued.
So Ms. McLeod, you didn't, she's not represented by a public defender or conflict attorney in regards to the battery and the affray, to your knowledge?
Not that I'm aware of, Your Honor. She certainly was not represented by me in that.
Okay, all right. And have you determined whether or not she is going to be able to be represented by, I don't know if you just answered this or not, so apologize. If are you going to be able to represent her going forward?
I will be, yes.
Okay, so if that's the case, then maybe you can check into that battery and affray, given that those are misdemeanor offenses also. I'm going to give her $1,000 good bond, no further contact with Mr. Jones, stay away from Clifton's, and no drugs, alcohol, or weapons while out on bond. But if you want to get these on one of my SAP calendars, all three together, if that's something that you'd be interested in, then maybe we can move all three of them forward that way.
And Your Honor, the state would actually make that request that they all be placed on the next SAP, just so whoever gets this case, even if Ms. McLeod doesn't end up remaining on this case, that they can all be addressed together with a global resolution.
Yeah, that makes sense. Okay. All right. Good luck to you, Ms. White.
Thank you, Your Honor.
Who do we have next?
Position 30 and 31, Judge.
Okay. Good afternoon, Ms. Wilkie. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Wilkie, you've been charged in case 23 CR 000432C with giving false information to law enforcement officer, and two counts of that. And in case 23 CR 000433C with theft by shoplifting. Is there a history, Mr. Howard?
17. Last arrest was on the 13th of this month out of Douglasville. Possession of a Schedule 2, given false name. July 2022, felony theft by taking out of Roswell. 2021, felony theft by receiving. 2020, battery DV. Simple battery, family violence conviction, 2019. Disorderly conduct conviction from 2018. It was amended from a shoplifting. Shoplifting conviction 2016, 2012, 2010 probation, underlying charges, forgery. I'll leave it at that.
Okay, Ms. Park.
Yes, Your Honor. She's currently out on a $5,000 surety bond on the theft by receiving. That is under 23 SC 185656. And that case, she was alleged to have stolen jewelry, makeup, clothes belonging to Carl DeCecia and Kelly Hogshead. So that case is currently open. As far as this case is concerned, in regards to the theft by shoplifting, this happened back on November 16th of 2022 at 2300 Holcomb Bridge Road, which is the Kroger. This defendant, as well as another defendant, Jaquarius Winters, entered that location and separated. The video shows that they went in separate directions, loaded up 2 separate carts, and then walked out of the store, walked past all points of sale with groceries and paper goods, which is what led them to be arrested. Winters then pushed his cart to a silver Honda Civic, threw all the items into the car, and then ran away from the car. And Miss Wilkie pushed her cart out of the parking lot to the Shell gas station. And she was at that time identified by the person at the store. I believe that is Miss Kimbrough. So that was the first case. On the second case, the officers were dispatched, and while they were placing Miss Wilkie under arrest, she gave them the false name of, let's see, just one moment. She gave them the false name and date of birth. She gave the name Heather Sears, date of birth May 31st, 1990. This was during a traffic stop where the vehicle was being driven by, let's see, Mr. Winters, who was the driver of the vehicle, and Miss Wilkie was the passenger. And when one of the officers arrived at the location, he recognized Miss Wilkie from previous incidents and then asked her for her first and last name and date of birth, at which point she gave the false first and last name and date of birth. And when they finally got her correct first and last name and date of birth, they found that she had the outstanding warrant, which is what she was arrested for. So that is essentially the bulk of these 2 cases. The state is asking for a $1,500 surety bond on the theft by shoplifting, a $500 surety bond on the 2 counts of giving false name, for a total of $2,500 surety bond. We do have some concerns with this defendant. Quite frankly, the only reason we weren't able to transfer this up as a felony is because one of her 3 previous shopliftings was in municipal court. And so upon her conviction on this shoplifting, she will be going forward as to any shoplifting, be eligible for a felony. So the state is taking this matter a little differently than we would a normal shoplifting, just due to the 3 prior shopliftings that this defendant has. We're also asking that she stay away from the Kroger, and that she have no alcohol, drugs, and weapons, and have no further contact with her co-defendant, which is in the first and second case, Mr. Jaquarius Winters.
Ms. Kim?
Yes, Your Honor. Mr. Wilkie, Miss Wilkie is 33 years old, Your Honor, and she has 3 minor children, 4, 8, and 10. She's a single mother. She used to work about 1 year ago as a home live-in caregiver for elders, but last whole year, she was not able to get any employment. So she's qualified for public defender services, and we will be continuously representing her. She has a 1 year of college education for criminal justice, and Your Honor, she does not even have a car because it was impounded at Douglas County. She was there for about 1.5 weeks at Douglas County, and then she was transferred to Fulton County Jail on January 21. We would like to request for a signature on bond, and yet if Your Honor is not inclined to give him a signature on bond because of past histories, we would like to request for $1,000 good bond remain as is, which is set already. Thank you.
And Your Honor, just to fill in the blanks a little bit about kind of the disconnect, when this incident happened, the giving false name, she did state that her stomach was hurting due to her, at the time she was pregnant, and then she was transported to Northside Hospital and then released from there. So she didn't actually go into our jail from that traffic stop, which is why there's a disconnect of time.
Okay. For the giving false information, it's going to be a $250 good bond for each charge. And for the theft by shoplifting, a $500 good bond makes a total of $500 good bond. So it makes a total of $1,000 good bond total for the two cases. No further contact with Mr. Winters. Stay away from the Kroger, and no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Wilson.
Position 26, Weems.
Good afternoon, Mr. Weems. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Weems, you've been charged in case 23 CR 000418B with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
Yeah, 7 total. Last arrest was, hold on. Got the same cycle. I see a theft by receiving. Okay, he got an aggravated assault first offender from 2020. They gave him 1 year probation for that. That's family violence. 2017, suspended license NOLO. 2017, misdemeanor possession of marijuana and misdemeanor obstruction. Those were dismissed. 2015, sale of marijuana arrest. 2013, obstruction. It was NOD. That's it.
Okay, Ms. Falk.
Yes, Your Honor. This incident happened November 29th of 2021 at approximately 4:32 p.m. Officers were dispatched to 2931 Middleton Road, apartment 288. They spoke with Miss Arnesia, that's ARNISIA, Williams, common spelling. Miss Williams stated that she and her ex-boyfriend, the defendant McKeel Weems, had been in a verbal altercation while he was dropping off their children at the apartment earlier that morning. While he was dropping off the children, during the verbal dispute, the defendant struck her in the face 5 times, leaving her with a black eye. The officers were able to observe that black eye to Miss Williams. Miss Williams stated that as a result of this, she ended up having to obtain a knife and chase him off. She stated this is an ongoing issue when she spoke with the police, and this did happen in the presence of her 3-year-old child that she shares with the defendant, MW. I will point out, and I want to make this clear on the record, the aggravated assault that the defendant had in 2019, he did complete first offender and it was sealed as a result. That too involved Miss Arnesia Williams. And in that case, it involved him pointing a shotgun at her. He was sentenced and given that 1 year probation under first offender in July of 2020, which would have put his probation up in July of 2021, which means this happened about 5 months after he got off of probation for a previous offense involving the same victim. Additionally, we have the statement that she made to police stating that this is not the first time that this has happened and this has been an ongoing issue. So for those reasons, we do have some serious concerns about the safety of Miss Williams, especially when it comes to Mr. Weems. This was a child drop-off. This wasn't them living together and snuggled up together. This is literally him dropping off the child that they share, and it devolved into him punching her repeatedly in the face. We have spoken to Miss Williams. She stated that they are not in a relationship. They do not live together. They do share 2 children. This did happen inside of her home. She stated that they have been co-parenting and that she also stated this has happened before, but he was never arrested, which is contrary to what we were able to locate from that 19 SC case, since he not only was arrested, but did plead guilty and enter that plea. She also stated she is not in fear of the defendant. However, we disagree given the offenses, the previous offense and this most recent offense, that there should be continuous contact. We are asking for no further contact, a stay away order from her address. We are also asking for a no alcohol, drugs, and weapons. And finally, we are asking for a bond of $10,000 as a surety bond. Thank you.
And the breakdown of the
that's going to be $7,500 as to the battery, family violence, and $2,500 as to the cruelty to children. Again, the state understands that he did complete probation on the previous case, but that does go to risk of reoffense, being it involved the same victim, involved a gun, and in this case, their 3-year-old child witnessed the abuse to his mother.
Ms. Kim?
Yes, Your Honor. Mr. Weems is 26 years old, Your Honor. He has been unemployed for the last 2 years. And his highest level of education is 11th grade. He did not complete GED, but he is planning to go back and get GED. His father passed away and left car wash detail business. However, it is not making much profit at this point. So he will be qualified for public defender's services. So our office will continuously represent him. And Your Honor, he has no objection to no further contact and stay away from Miss William, as long as he gets third-party transfer for the children, because he wants to have a relationship with his 2 children who are 4 and 5 right now. That's it, Your Honor. We would like to request for $2,000 good bond maximum. Thank you, Your Honor.
And Your Honor, Miss Williams is here if you would like to sound for her. If she would like, I don't know if she would like to make a statement, but I will put on the record that state has no objection to a third-party contact with the children.
All right, Ms. Arnesia Williams, if you're present, this is your opportunity to address the court. You do not have to address the court, but if you would like to address the court, now is your opportunity. I need for you to, if you would like to address the court, activate your camera and I'll have to swear you in.
Okay.
All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. What would you like to tell the court, Ms. Williams?
I'll say that since this incident, we have been doing better. We have put that behind us. For the kids, we have been co-parenting and everything has been smooth since then. The kids, they enjoy seeing their father and they are building a better relationship. So I would just like to say that if the charges can be dropped and I don't know, just if the charges could be dropped, I would like that. But we have put this situation behind us. So that's it. That's all I'd like to say.
Are you all still together or not?
No, we are not together.
Okay, so you don't live together and you, but you do co-parent the children?
Yes.
Okay. Ms. Falk, anything?
Yes, Your Honor. Ms. Williams, just to clarify, when you say the situation, are you referring to the situation in which the defendant punched you in the face?
Yes, I am.
Okay, that's all from the state, Your Honor.
All right, so for the battery, it's going to be a $2,000 good bond. For the cruelty, $1,000 good bond, making for a $3,000 good bond. Until this is cleared up, Ms. Williams, there's not going to be any further contact and he's to stay away from the Middleton Road address. He can see his children, but he'll have to have third-party transfer for visitation with the children and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Williams, and you also, Ms. Williams.
You said 3,000 total?
Yes.
Okay.
Who do we have next?
Position 22, Nance.
Good afternoon, Mr. Nance. I'm Judge Eric Morrow. This is the state for the expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Nance, you've been charged in case 23 CR 000415F with battery. Is there a history, Mr. Howard?
I don't see that file. NIMS?
Yeah, position 22. Ms. Lewis, do you have the history?
Yes, Your Honor, I have that he's arrested in 2015 for simple battery violence in 2020, as well as theft by taking in 2020. No previous convictions, though. These are all, I'm sorry, the 2020 cases are still open.
Okay. You can proceed, Ms. Lewis.
Yes, Your Honor. This incident occurred January 19th at 3273 Sim Street in Hateville. Officers responded to an assault call where they met Jessica Givens. Givens stated that her and her boyfriend were in a verbal altercation which escalated. Givens stated that Nims was so angry that he struck her multiple times with his hand. He also hit her in the head with a 5-gallon cooking pot. The officer who responded observed bruising to her face and noticed that the top of her head was swollen with discoloration and bruising. Your Honor, because this defendant does have a history of violence, the state is recommending a $5,000 surety bond, which is an increase to the current $2,500 surety bond he currently has. No alcohol, drugs, or weapons. To stay away from that location, no further contact with Ms. Givens, and 1 day anger awareness. Nothing further, Your Honor.
Ms. Melvin?
Yes, Your Honor. My client understands he has family that he could go and live with, and we're asking the court to keep the $2,500 bond that's in effect, because eventually he is unemployed, and eventually that's a no bond for him. So we're asking the court to just keep it as is.
Okay, I'm gonna leave it where it is. $2,500 good bond, no further contact with Ms. Givens, stay away from the Sam Street address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Nims.
Thank you, sir.
Position 2, Allen.
Good afternoon, Mr. Allen. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Allen, you've been charged in case 23 CR 0000422H with simple assault family violence and simple battery family violence. Is there a history, Mr. Howard?
16 total. His last couple of arrests was for DUI. As far as violence, he got a 2010 cruelty and a third simple assault, simple battery conviction out of Carr County. 2010 misdemeanor possession of marijuana, and before the 2010 was 1999.
Okay. Mr. Rogers?
Yes, Your Honor. On January the 22nd, 2023, officers were dispatched to 4555 Washington Road, 22J in South Fulton. When officers arrived, they made contact with Nakia Gardner, first name Nyika, last name Gardner, common spelling. Ms. Gardner stated that her husband, Mr. Anton Allen, approached her in a bedroom, and he asked her why she didn't answer his phone calls. She then advised that Mr. Allen slapped and punched her in her face multiple times. Miss Gardner did state she asked the Mr. Allen why was he hitting her. He then picked up a Glock handgun, a black handgun, and stated, you are lucky that I'm just hitting you and don't blow your head off. Miss Gardner then retreated to the guest bedroom and called the police. Then Mr. Allen did leave the residence upon recognizing that Miss Gardner was calling the police. Police did arrive at the scene, and that's when I obtained the evidence and the warrant was issued. It is problematic for the state because Mr. Allen is a convicted felon, and he is have alleged to have brandished a weapon to his wife. We did speak with the wife. She did state that they are married and live together, but they share no children. And she will be filing for divorce next week. She said this is not the first time that he's put his hands on her, but this is the first time that she has involved the police the criminal justice system. She stated that she just want him to come back, be allowed to come back to the residence one time and get his belongings with a law enforcement officer. For these reasons, the state is requesting a $20,000 surety bond, $15,000 for the battery, family violence, and I'm sorry, $15,000 for the simple assault, family violence, and $5,000 for the simple battery violence in lieu because he did brandish that weapon and because he is a convicted felon. The reason why the DA's office did not take up that firearm charge is because a weapon was not recovered. We also asked for a stay away order from that address and no further contact with the victim, Your Honor.
Okay, thank you. Ms. Kent.
Thank you, Your Honor. Mr. Anthony Allen is 48 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here, including his mother and his siblings. He did confirm that he is in fact going through a divorce from the complaining witness, Ms. Nika Gardner. Mr. Allen completed the 11th grade and he is currently employed as a machine operator at a Porex company. He has been in that position for about 4 months. Mr. Allen strongly denies the allegations, Your Honor. I do acknowledge my client's history. However, his last conviction for violence was over 10 years ago. And regarding the state's bond recommendation, they are basically treating my client as if he is charged with a felony. I'm asking for a signature bond on Mr. Allen's behalf. If Your Honor determines that he is inclined to receive a signature bond, then I would ask for a more reasonable bond, Your Honor, no more than $1,500, $1,000 for the simple assault, $500 for the simple battery, family violence, Your Honor. My client is requesting no violent contact as he is pro se at this point in terms of handling the divorce. So there will need to be some communications. I did reach out to Ms. Gardner. She confirms that she wants to have no violent contact as well for the same reason. We are unopposed to the one-time law enforcement escort. My client does state that he has belongings there. He is requesting more than one time. He states that he has items for work there, including TVs that are mounted to the wall. So he wants to ensure that he has enough time. And finally, Your Honor, we are unopposed to the stay away. Thank you.
All right, Ms. Gardner, I see you on the line this afternoon. This is your opportunity to address the court if you choose to. Of course, you do not have to. If you would like to address the court, I'll need for you to raise your right hand for me. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes,
Okay,
I do.
you can put your hand down, ma'am. What would you like to tell the court?
Yes, everything that I told the officers is definitely true, but he's really sick and things like this happens when he's under the influence extremely. I am moving forward with the divorce. I'm not opposed to him getting all of his things. If it's going to be more than one time, I just ask that law enforcement officer is with him every time. So I'm not opposed to that, but he's really sick. If this does not happen until he's extremely under the influence of whatever he's under the influence of at the time when things like this do happen. So the divorce is definitely going to move forward. And if it's going to take more than one time, as long as the law enforcement officer is present, then I'm not opposed to that, but I don't want any contact with them.
Okay, thank you, Ms. Gardner.
Thank you, Your Honor.
You're welcome. If nothing further, it's going to be a $3,000 good bond for the simple assault, a $2,000 good bond for the simple battery, making for a total of a $5,000 good bond. No further contact with Ms. Gardner. Stay away from the Washington Road address. He can go back to that address with law enforcement to retrieve any belongings that he may have, and drugs, alcoholic weapons while out on bond.
And Your Honor, the law enforcement, is it one time or any?
No, he can, if he needs to go more than one, he can go more than one, but every time he goes, he's gonna have to have law enforcement accompany him.
Thank you,
Okay,
Your Honor.
all right. Good luck to you all, Ms. Gardner and Mr. Allen. Who do we have next?
Assistant 3, Anderson.
Good afternoon, Mr.
Oh,
Anderson.
I'm
Judge.
sorry,
Thank you.
jail court, we can let jail court's iPhone go next. I mean, they
Okay.
can go now.
Okay.
Thank you. This is Mr. Sampson Wilson. Wilsino.
Oh, 29.
And he said he wants to represent himself, Your Honor.
Okay. Has anyone spoken with him? Have you spoken with him, Ms. Kim?
No, Your Honor, I was refused
Okay.
to speak with him.
All right, Mr. Wilsina, I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Mr. Wilsina, you've been charged in case 23 CR 0000427Y with one misdemeanor offense. Is there a history, Mr. Howard?
Yes. Let's see. Last arrest was December out of the cab. 1 count battery, 2 count simple battery. November, theft of services out of Clayton County.
Yep, the airport.
And another November arrest out of Woodstock for disorderly conduct, criminal trespass. Let's see. We got a 2021 fugitive from justice warrant. I think that was out of maybe Massachusetts.
Worcester, Massachusetts.
2014. What we got? Obstructing a police officer conviction.
Yeah, they shot me 11.
Okay, Mr. Wilson, you have a right to remain silent. Anything you say can be used against you, okay? So you don't have to comment on what Mr. Howard's saying, okay?
Yes, sir.
All right.
This is the Nebraska history. It was a 2014 robbery as well. 2014 criminal mischief. 2014 obstruction conviction. And the other charges were dismissed with that arrest. That's all I see.
Okay, Ms. Falk.
Your Honor, I will say that I do think an MHET may be necessary in this case based on the facts and the defendant's history. I am only basing it on that. So I do not have any, I just want to be clear, I don't have any additional information to offer other than the bare facts of this case, as well as his history based on my experience, especially working with MH court. It looks a little similar to some patterns I've seen there. That being said, this happened January 23rd, 2023. It happened at the Marta Lindbergh station at 2420 Piedmont Road Northeast. Apparently this defendant exposed himself to Miss Brianna Baker, and that's BRIAUNA. Baker, BAKER. He also began licking the bus glass and called her a bitch. And so based on all of that, the defendant was placed under arrest and was charged with PI. We are requesting a $3,000 surety bond. We are further requesting he stay away from the MARTA station at Lindbergh. That's 2420 Piedmont Road Northeast, Atlanta. We're asking for no alcohol, drugs, and weapons. We are asking for an MHET, and we are asking for no further contact with Brianna Baker. I don't know if I'd already stated that, but it never hurts to say it twice. So that is what the state's recommendation is at this time. We are basing our recommendation on his very checkered and lengthy history, both here and in Nebraska.
Okay. Ms. Kim, are you with me?
Yes, Your Honor.
Would you indulge the court, please? And I want Mr. Wilson to have a social worker visit before the SAP calendar. So would you please arrange that for the court so that if he is still in custody at the SAP calendar, they can report to me. If they do find that an MHET is necessary, would you also make the court aware of that, please?
Sure. Yes, Your
Okay,
Honor.
as such, at this time, it's gonna be a $3,000 good bond. Stay away from the MARTA station at 2420 Piedmont Road. No further contact with Ms. Baker. No drugs, alcohol, or weapons while out on bond, and a social worker visit to assess his mental health. Okay, good luck to you, Mr. Wilson. Who do we have next?
Position 3, Anderson.
Good afternoon, Mr. Anderson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, Judge. Yes.
Good afternoon, Mr. Anderson. You have been charged in case 23 CR 000424E with simple battery family violence. Is there a history, Mr. Howard?
32 total. Last arrest was in 2019, possession of cocaine dismissed. 2017, 2018 driving offenses. Failure to appear 2015 for driving. 2013 probation violation, ag stalking. That came off of a 08 SC 72426 case. 2012, 2011 probation. 2010, 2 counts of battery conviction. And before that was the ag stalking and obstruction conviction.
Okay. Mr. Rogers?
Sorry about that. On May the 14th of 2021, officers responded to 30 Alabama Street Southwest. That's the 5 Points MARTA station. They were met by Ardell Teasley, first name Ardell, last name Teasley. Sorry. She's the victim in this case. She stated that her son's father, Mr. Xavier Anderson, slapped her when he was exiting a train on the southbound platform at the 5 Points MARTA station. As he was stepping off, he turned around, stepped back into the train, and he slapped her. And those are the facts, Your Honor. Based on Mr. Anderson's past, he has as court staff mentioned, he has a conviction for aggravated stalking and for battery, even though it were in 2010 and 2008. It still is concerning for the state. We're asking for a $3,500 surety bond and a stay away order from the victim, in this case, Miss Teasley.
Have you spoken, your office spoken with Ms. Teasley?
We reached out to Miss Teasley, but we were unable to reach her based on the last note I saw.
Okay, Ms. Gant?
Yes, Your Honor, Mr. Xavier Anderson is 43 years old. He has been in the Atlanta, Georgia area his entire life. He is the proud father of 9 children, ages 21, 20, 18, 14, and he has a set of twins, age 17. He shares a 2-year-old child with the complaining witness, Ms. Teasley, Your Honor, and he states that he is paying child support for his children. Mr. Anderson completed high school. He also has college credits. He attended Morris Brown College. He studied to be a chiropractor and a computer technician. At this time, Your Honor, he is currently employed as a forklift operator at DSV. He has been in this position for about 7 months. He strongly denies the allegations. I did reach out to Ms. Teasley through his sister. She did not get back in contact with me, Your Honor. So I have not spoken with Ms. Teasley. Therefore, we are requesting we will comply with the court's order regarding contact. We are requesting a signature bond on Mr. Anderson's behalf. Mr. Anderson does not have the means to pay anything toward bond. He states that he actually has been assisting with living expenses for Ms. Teasley as she lives in a hotel and that she's currently pregnant with his child, Your Honor. So we certainly would request a no violent contact order, but certainly respect the court's procedures. There is no need for a one-time law enforcement escort. And again, we're requesting a signature bond as he does have a remote history of violence along with the FTAs and the probation violations, Your Honor. Thank you.
All right, it's gonna be a $5,000 signature bond through the jail. Since no one has contacted Ms. Teasley at this point in time, no further contact with Ms. Teasley, third-party transfer for visitation of any minor children, and no drugs, alcohol, or weapons while out on bond. Certainly, if someone's in contact with Ms. Teasley, and Ms. Teasley wishes to have contact, that will be taken into consideration, and you can seek a modification of this bond order. So, Mr. Anderson, given that no one's spoken with Ms. Teasley at this point in time, you could have no contact with her at this point in time. But if there is a modification, then we'll see what happens down the road. Okay. All right. Good luck to you. Yes.
And Your Honor, I do apologize for interrupting after your ruling, but I do want to clarify. I believe I may have misspoken. Mr. Anderson, I do need to clarify whether or not he has any belongings in Ms. Teasley's room. I believe the answer was no. Mr. Anderson, may you clarify that for me, just with the yes or no answer?
No, ma'am, I do not.
Okay, thank you, Your Honor. I do apologize for interrupting.
You're fine. Good luck to you, Mr. Anderson.
All right, thank you.
Thank
You're
you.
welcome.
Mr. 19 Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Moore. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jones, you've been charged in case 23 CR 0000414Y with pedestrian must walk on the sidewalk, possession of use of drug-related objects, and obstruction of a law enforcement officer. Is there a history, Mr. Howard?
Third arrest. Last arrest was 2021. Possession of cocaine, possession of a knife or a firearm during the commission. Case number 21 CP 197695. And before that was 05, possession of a knife or a firearm during the commission, ag assault, carrying concealed weapon, pointing or aiming pistol at another. Two of those charges were dead docket, the other two were not prosecuted. So he just got the open case.
Lewis?
Yes, Your Honor. This incident occurred on January 21st at 595 Piedmont Avenue. Officers responded to an armed person call at the intersection of Piedmont Avenue and North Avenue. Upon arrival, the officers met Mr. Jones and told him to stop so they could speak. Jones ignored his commands and proceeded to run into the roadway and into the oncoming traffic. Jones ended up running into the Publix parking lot, which is the address listed 595 Piedmont Avenue, where he was apprehended. Once apprehended and searched, the officer found a loaded 9mm handgun as well as silver drug scales. Your Honor, this defendant has a history of being arrested for possession of firearms in the commission.
Your Honor, I'm sorry. I'm so sorry to interrupt. I did not see anything in the report about a gun. And he is not charged with a gun.
It's in the police report.
I'm looking at the affidavit for arrest, and he wasn't charged with a gun either. I'm looking at, I mean, I'm not, I don't have, all I have is his arrest warrant.
It's in the incident report. We're just stating the facts.
Well, apparently he had a gun legally, right? So if he had a gun, it was legal.
Okay.
Otherwise, he would have been charged with it. That's what I
Right,
get.
because it never said that in the affidavit for arrest.
Okay.
Sorry, I just want to make sure we're, that was.
Right, yeah, I don't have a gun charge.
Yes. Or in the arrest warrant that was signed by Judge Treadwell, it does not say anything about a gun either.
Okay. Continue, Ms. Lewis.
Yes, Your Honor. Because of the defendant's previous cases, the state is recommending a $15,000 surety bond. That's $3,000 for each count. That's $3,000 for the pedestrian must walk, $3,000 for possession and use of drug-related objects, and $3,000 for the willful obstruction of law enforcement. We are also recommending no alcohol, drugs, or weapons, Your Honor.
I'm sorry, why did they stop him?
They responded to an armed person call, and the incident report does vary from the arrest report, but in the incident report, the officer did search and obtain a loaded 9mm handgun.
So I don't understand. People can have a gun. So if you, right?
Right, yes.
Yes, Your Honor. I'm assuming that someone in that area is a public shopping center, saw him with the gun and they alerted the police.
Well, people have
and
guns
just
everywhere.
responded.
Apparently, people can walk around with guns these days. So if you call the police on everybody that has a gun, then people are gonna be calling the police left and right.
Your Honor, I don't dispute people call police for guns all the time. I think the difference here is what triggered the stop was the fact that the defendant, when they tried to make contact to find out what was going on, took off from the officers and fled across the street, which then triggered the pedestrian on the roadway because he was not using the sidewalks. When I mean, it is a fact. I mean, he ran from the officers and ran across the street. It's a misdemeanor offense. I mean,
Yes, Your Honor, it's a very serious misdemeanor offense, Your Honor. And I'm sorry.
Okay, I got you, Ms. Melnick.
Okay, I'm just like,
and Your Honor, I'm just
Hold on.
establishing what the probable cause is.
he's not done anything wrong is what the probable cause is. He's not done anything wrong. And then to go with a pedestrian on a sidewalk.
I'm not
for a
disagreeing
signature
with
bond
Ms.
of
Melnick. Ms.
$500.
Melnick, I'm not disagreeing with you.
Okay.
$1,000 signature bond through the jail on each charge. $3,000 signature bond through the jail. No drugs, alcohol, weapons. Well, no drugs or alcohol. If he has a valid weapon, he can have his weapon. No drugs or alcohol.
Thank you, Your Honor. I'm sorry. It's just.
Was that a total 3,000 signature, Your Honor? I didn't hear you.
It's $1,000 signature bond on each charge, making it for a total of a $3,000 signature bond through the jail.
I'm sorry. There's just protests on Saturday night and we're getting him for running in the sidewalk. I'm sorry.
Who do we have next?
Position 25, Sims.
Okay, tell me again. Where are we?
Position 25, Sims.
Okay, good afternoon, Mr. Sims. I'm Judge Eric Mora. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
All right, Mr. Sims, you've been charged in case 23 CR 0000421A with criminal trespass and public drunk. Is there a history, Ms. Lewis?
Yes, sir. This.
I'm sorry, Ms. Lewis. We're getting to a late hour, but a little bit discombobulated. Mr. Howard.
Yeah, my ADD kick in about 4 o'clock anyway. But 23 total.
Okay.
Last arrest was back in December. Trespass at Marta. November, shoplifting, Chambly. September, trespass, PI at Marta. July, trespass, Dorville. April, failure to appear for public intoxication, Dorville. March, trespass. February 2021, disorderly conduct. 2015, failure to appear, not prosecuted. 2014, probation, trespass, battery DV. It came off 11 SC 103770. 2013, trespass. 2013, battery DV, obstruction. 2013, disorderly conduct conviction. And you got those open cases I talked about. And 2011, burglary, simple battery, family violence, probation. I'll leave it at that.
Thank you, Mr. Howard. Ms. Lewis?
Yes, Your Honor. This incident occurred January 21st. Officers responded to a disorderly conduct call at 2420 Piedmont Road, which is the Lindbergh MARTA station. The officer stated that Sims remained at the MARTA station after he was given a verbal criminal trespass warning previously. Sims refused to leave the station. The officer also stated that Sims had a strong smell of alcohol from his person and made a scene cursing and using profane language. The officer also stated that at one point, Sims asked him if he wanted to fight. Your Honor, the state is recommending a total $2,000 surety bond. That's $1,000 for each count. No alcohol, drugs, or weapons, and to stay away from the Lindbergh MARTA station, which is at 2420 Piedmont Road. Nothing further, Your Honor.
Ms. Kim?
Yes, Mr. Sims is 45 years old. He's been here in Georgia for about 22 years, and he has 4 boys and 1 girl, 5 children total. He is also gainfully employed for 2 different jobs, one floor tech and the other one is flagging. He works at staff zone temporary services. He's had those jobs for the last 3 years. His highest level of education is 12th grade. After he dropped out at 12th grade, he got GED. Your Honor, he does have a disability as well. He has a broken femur. He also gets seizure time to time, and he has a dislocated disc. And yet he's doing his best to be productive. So we would like to request for signature on bond for these charges so he can go out and be working so he can take care of his 5 children. Thank you.
$1,000 signature bond through the jail on each count, $2,000 signature bond through the jail total. No drugs, alcohol, or weapons while out on bond. Stay away from the MARTA, the Lindbergh MARTA station. All right, good luck to you, Mr. Sims.
Thank you, sir.
Judge, you said 2,000 total, correct? SOB through the jail?
Yes, 1,000 for each charge.
Thank you. Position 14, Jackson.
Good afternoon, Mr. Jackson. I'm Judge Eric Mora. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jackson, you've been charged in case 23 CR 0000411C with criminal trespass. Is there a history, Mr. Howard?
His 8th adult arrest. Last arrest was 2019 battery DV conviction. Criminal attempt to commit a felony conviction. He's on probation for that out of Coweta County. In 2017, they gave him 7 years probation for that. 2017 probation violation. Got a shoplifting that was NOD. That was from 2015, along with a probation violation. Sell of marijuana conviction, 2015. He's on probation for that out of Coweta. In 2015, they gave him 10 years probation for that. 2012, sell of marijuana. 2011, criminal damage to property, 2nd degree. Unsaid disposition for that. That's it. His first cycle was a juvie.
Mr. Abdullah?
Yes, Your Honor. The facts show that on January 22nd, 2023, the defendant was stopped for entering through the gates of East Point train station without paying the proper fare. The defendant was on MARTA's property in violation of an active MARTA suspension. For this reason, the state is recommending or requesting a $2,000 signature bond through pretrial and for the defendant to comply with all MARTA suspensions, as well as no weapons, drugs, or alcohol while on bond.
Who's representing Mr. Jackson?
Sorry, I thought my camera was on. Yes, Your Honor.
Do you have any objection? It's going to be a $2,000 signature.
That's fine, Your Honor.
Through the jail and abide by any MARTA restrictions. Is that fine with you?
Yes, Your Honor, unless you just want to hear me argue.
Any other time, Ms. Melnick?
That's right. I'll hold my breath for that.
All right. Good luck to you, Mr. Jackson.
Your Honor, what was that, that bond amount? I'm sorry.
You're fine. It's a $2,000 signature bond through the jail.
Through the jail. All right, thank you.
Okay.
Next, I have position number 23, Mr. Padgett.
Looks like courtroom 2 is frozen. Mr. Padgett, can you hear me?
Yes, Your Honor.
Okay, good afternoon. I'm Judge Eric Mora. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 0000416C with simple battery family violence. Is there a history, Mr. Howard?
Yeah, 7 total. He's on probation. Ag assault, battery, reckless conduct, reckless driving. 17 SC 155-399. He got probation once for those. 2019 simple battery. 2017 probation. He got driving from 2011, expired license conviction, disorderly conduct conviction from 2009. That's all.
Okay, Ms. Lewis.
Yes, Your Honor. This incident occurred November 10th, 2020. Officers responded to 1059 Oglethorpe Avenue Southwest and spoke to Tonda, that's spelled T-A-N-D-A, Coffer, C-O-F-E-R, who is the mother of Padgett. Coffer stated that Padgett came home to their apartment intoxicated. A verbal argument ensued between Padgett and Coffer's other son, Angelo Coffer. Coffer stated that when she tried to defuse the situation and break her sons up, Padgett began to attack her, striking her multiple times. Ms. Coffer stated that Angelo Coffer, who is her other son, had to pull Padgett off of her. Let's see, the state is recommending a $5,000 surety bond, no alcohol, drugs, or weapons, to stay away from 1059 Oglethorpe Avenue, no further contact, and 1 day anger awareness. Your Honor, I'm not sure if Ms. Coffer is on the line, but if she is, we'd like to sound for her at this time.
Ms. Coffer, are you on the call today? Have you had the opportunity, Ms. Lewis, to speak with anyone in your office to speak with Ms. Coffer?
We called this morning and left a voicemail. We weren't able to reach anyone.
Okay, thank you. It doesn't appear that she's with us, Ms. Lewis. Ms. Melnick?
Yes, Your Honor, I would like to note the remoteness of this case. This is from a November 10th, 2020. This was, basically, I rarely say this, but my client has actually turned himself around since this time frame going through. He has since remarried Rashida Arnold, and he's totally turned his life around. He's now a mechanic. He has a very successful business. In fact, he's not even going, when he's not in jail, he will not even qualify for the services of the public defender's office. This, he has not been in any trouble since then. And we'd asked, he lives at 100 Harvest Grove in Conyers, Georgia. So we'd asked the court just to consider all this, that this was so remote ago. I'm not saying it's not serious, but it was a simple battery. And he's since moved on and changed his life around.
All right, it's going to be a $3,000 signature bond through the jail. No further violent contact with his mother, Ms. Kofer. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Padgett.
You said 3,000, how much?
3,000 signature through the jail.
You want to say something? Okay. No. Okay, Your Honor, thank you.
You're welcome. Good luck to you, sir.
Yes, sir. Next, we have position number 1, Mr. Ryan Adams.
Good afternoon, Mr. Adams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 000407E with battery. Is there a history, Mr. Howard?
He got over 20 arrests. Last arrest was in May out of Woodstock. DUI, possession of a Schedule 2 controlled substance, 2 counts. Possession of drug-related objects, drugs not in original container, theft by possession of stolen mail, fraudulent ID, forgery in 2nd degree. That appears to be open. Let's see. April of last year, felony theft by receiving, identity theft fraud out of Cobb. That's open. 2022 February, Cobb County DUI. 2019 sale of marijuana out of Twiggs County. That was dismissed. 2018 probation, another 2018 probation, and another one. 2017 probation. 2016 probation. He got a few cycles out of Florida as well. Yeah, he got a burglary conviction. That's it.
Okay, thank you. Mr. Rogers?
Yes, Your Honor. On January 21st of 2023, officers were dispatched to 1695 Northside Drive in reference to a dispute. Upon arrival, Melania Clark, first name M-E-L-A-N-I-A, last name Clark, common spelling, advised that Ryan Adams had physically assaulted her while they were inside of a vehicle driving northbound on I-75. He did so by grabbing and hitting her in the back of her head, causing swelling, and also scratching on her right shoulder. We asked for a $4,000 surety bond, no further contact with the victim, no drugs, alcohol, or weapons while out on bond, and a 1-day anger awareness. That's all, Your Honor.
Okay. Ms. Gant?
Yes, Your Honor. Mr. Ryan Adams is 33 years old. He has been in the Atlanta, Georgia area for 15 years. He has a 6-year-old daughter. Mr. Adams has some college, about 3 years. He studied international studies. He states that he is a tow truck operator. He owns the company. He has been doing this for about 3 years. He strongly denies the allegations, and Mr. Adams is presumed innocent in any open cases, including this case. He does have some history. I do acknowledge that. However, his violent offenses are quite remote, Your Honor. I am requesting a signature bond on Mr. Adams' behalf, and if Your Honor determines that he's ineligible, then bond of no more than $1,000. We are asking for no violent contact. However, I did reach out to Miss Malaria Clark, and she states that she does not want any contact at this time. Therefore, we will defer to the court's ruling. Now, Mr. Adams did state that he has a car and money that Miss Clark is in possession of. So we would ask for a one-time law enforcement escort so that he can retrieve whatever belongings she has of his, Your Honor. Thank you.
All right, it's $3,000 good bond, no further contact with Ms. Clark. Stay away from the North Side Drive address. You can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Adams.
Thank you, sir.
Thank you, Your Honor. And Your Honor,
yes, Ms. Gann.
Again, I do believe in this case, the 1695 is not Ms. Clark's address. I believe that's the incident location. So I would ask that if the courtroom too could, or if the state has it, her address, so that he would receive the one-time law enforcement escort to her address, to Miss Malaria Clark's address. I do not believe it's the 1695 North Side Drive. That's in the warrant, Your Honor.
Okay, so so he's to stay away from Ms. Clark's address. He can go back to Ms. Clark's address on one occasion to retrieve any belongings that he might have from there. Would that satisfy the requirement, Ms. Gant?
Yes, Your Honor. Thank you.
Okay, because I'm not sure. I mean, I'm happy to put the address on the record or in the order if we have it, but if we don't have it, then I'll word it that way.
Yes, that works, Your Honor. Thank you.
Okay, all right, very good. Who do we have next?
Position 8, Davis.
Good afternoon, Mr. Davis. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Mr. Davis, you've been charged in case 23 CR 000431D with escape. Is there a history, Mr. Howard?
50 total. On probation for burglary. 2018, they gave him 4 years probation for that. 15 SC 137530. Last arrest was back in May. Probation. Before that was 2020 probation. 2020 simple battery arrest. 2020 2 counts of trespass, 1 count of obstruction arrest. 2020 theft by taking arrest. 2019 simple assault conviction. Probation convictions 2019 failure to appear. 2018 theft by taking. 2016. Would you like me to keep going?
You're good. Thank you. Mr. Rogers.
Yes, Your Honor. On December the 30th of 2022, officers took Mr. Anthony Davis into custody on a warrant for a probation violation in regards to the burglary count. They took Mr. Davis to Grady Hospital for a medical clearance before being transported to Fulton County Jail. And while at the hospital, Mr. Davis did leave the hospital by foot. The state is asking for a $2,500 surety bond for that count of escape. That's all, Your Honor.
Ms. Gant.
Yes, Your Honor. Mr. Anthony Davis is 43 years old. He has been in the Atlanta, Georgia area his entire life. He is the proud father of 3 children, ages 22, 21, and 17. He completed the 11th grade, and at this time he's unemployed. He does not have any resources to make bond. He denies the allegations. He's presumed innocent. I'm requesting a signature bond, Your Honor. Thank you.
All right, $1,000 good bond, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Davis.
Thank you, Your Honor.
Thank you. Yeah, Judge Ellison.
Quick announcement, Judge, position for the medical reset.
For tomorrow, 124.
Yes.
Okay.
Also, we have a waive of appearance. I'm trying to see what, okay, position 28, waive their appearance. And that's it, Judge.
Okay. Got a waiver on 28. All right, thank you.
Thank
See
you.
you.
See you tomorrow.
Okay, see you in the morning.
All right. Be safe. Thanks.
What happened with Randolph?
We're not quite done yet. Let's position number 28 is a waiver. Withers. This is your case, Ms. Kim? You're on mute, yes? Yes? Okay. Mr. Howard, is there a history?
Yeah, he got 22 cycles. He been in jail since 2021. Ag assault. I got 2021 possession of a controlled substance, probation for robbery, sale of cocaine, possession of a firearm during the commission, possession by a convicted felon. Yeah, 2019 PI that was dismissed. Possession of a Schedule 4 conviction, theft by receiving conviction, 2019. You want me to keep going?
You're fine. Ms. Fogg, this happened while he was in custody in the jail?
Yes, that is correct, Your Honor. And it
Okay.
happened, this actually occurred in the presence of Nurse Haynes. She was the deputy was overseeing the medication distribution by Miss Haynes. When the defendant began touching himself inappropriately, the officer continued to give him verbal instructions to stop. At one point, he demanded that the deputy move so that he could continue to make eye contact with Miss Haynes while he was doing so. So this was pretty blatant at this point. The state's recommendation is a $5,000 surety bond. As the pretrial has stated, he did have a case from 2019 that did end up being dismissed for PI as well. So this is the second offense that he has been arrested on for the same type of charge. And given the fact that we have 2 witnesses to this, we are asking for a surety bond and that he have no contact whatsoever with Nurse Haynes. And I understand it is the jail, but the jail may just have to figure it out. But I don't want to have Nurse Haynes be subjected to him any further.
Okay, what's the breakdown?
Excuse me, 4,000 on the PI and 1,000 on the criminal trespass. I mean, of the obstruction, excuse me, 5 o'clock,
Okay.
my apologies.
No problem, I got you. Ms. Kim.
Yes, Mr. Whiters is 29 years old, and he has been in jail ever since June 20, 2021. He has no financial means to make any kind of bond. He also has an ankle monitor. He's not a flight risk, and he's been here for all his life. And Your Honor, without any income, of course, he's qualified for public defender's services. And we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 good bond, $500 each. Thank you.
All right, it's gonna be $1,000 good bond for each charge, making for a total of a $2,000 good bond. No further violent or harassing contact with Ms. Haynes. I'm not sure if she has to come into contact with him in the jail, but and no drugs, alcohol, or weapons. Okay, I have Ms. Bridgewater report with me today. I believe that completes the 2 o'clock calendar. So as soon as she is ready, we'll go over it.
Okay, once again, the reset date for the SAP calendar is going to be February the 7th. Position number 1 is set to the SAP calendar with a $3,000 good bond. Position 2 is going to the SAP calendar with a total $5,000 good bond. Position 3
That's SOB jail or good bond?
is on 2,
It's
on
a good,
3 is through the jail. SOB through the jail for position number 3. Position 4 is medically reset till tomorrow. Position 5 is going to the SAP calendar with a total $2,000 good bond. Position 6, we set further notice with a $5,000 SOB through pretrial per judge. Position 7, we set further notice with a $3,000 SOB through pretrial per judge. Position 8 is going to the SAP calendar with a $1,000 good bond. Position 9, we set further notice with a total $2,000 SOB through the jail. Position 10, we set further notice with a $2,000 SOB through pretrial per judge. 11 is reset to the SAP calendar with a total $2,500 good bond. Position 12 is reset further notice with a $3,000 SOB through pretrial per judge. 13 is reset further notice with a $3,000 SOB through the jail. 14 is reset further notice with a $2,000 SOB through the jail. 15 is reset further notice with a $4,000 total SOB through pretrial per judge. 16 is being reset further notice with a $2,000 SOB through pretrial. 17 is reset further notice with a total $3,000 SOB through the jail. 18 is going to the SAP calendar with a total $3,500 good bond. Position 19 is reset further notice with a $3,000 total SOB through the jail. Position 20 is reset further notice with a $1,000 SOB through the jail. 21 is reset further notice with a $5,000 SOB through the jail. 22 is going to the SAP calendar with a $2,500 good bond. 23 is reset further notice with a $3,000 SOB through the jail. 24 is going to the SAP calendar with a $3,000 good bond. 25 is reset further notice with a total $2,000 SOB through the jail. 26 SAP calendar with a total $3,000 good bond. 27.
you just did 26.
Huh?
I think you just did 26.
Yeah, I did 26, but I can write down 27, so I'll come right back to it.
I got 1,000 good for
I have
27.
1,000 surety.
Okay, so that's going to the SAP calendar with the $1,000 good bond. Position 28 is reset to the SAP calendar with a $2,000 total good bond. 29 is going to the SAP calendar, $3,000 good bond. 30 going to the SAP calendar with a $500 total good bond. 31 is going to the SAP calendar with a $500 good bond. And position 32 is going to the SAP calendar with a $3,000 good bond.
29 was 3,000?
29 I have as $3,000 good bond.
Yeah, it's time to go home. All right, Judge, I think that's it.
Can I just get clarification on position 2 and 3? What I heard was a $5,000 surety bond on 2 and a $5,000 signature bond on 3.
That is correct. That signature bond is through the jail. On number 3.
Okay, anything else this afternoon?
No.
Okay,
Nope.
thank you all. Have a
Thank
good
you, Your
rest
Honor.
I'll see
rest
you
of your
tomorrow.
day. I will
Have a
see
good
you-
day.
Be the same. I'll see you all tomorrow.
Have a good one.
Everybody ready to run about.